Good morning, good morning, good morning, and replay crew, good to see you. Go ahead and check out all the links below because everything is time-stamped. We have much to cover today, and I thought originally we would just be covering a court hearing. That was the plan, but then last night when I went and looked at the docket in Massachusetts in the case where Adam Lally was supposed to be resuming the stand today, I went and looked at the docket. There was a bunch of stuff on the docket, and then I was like, that's a bunch of stuff on the docket and a motion to continue. So when I saw all of that, I went over to the Law Nerd Lounge and was like, hey, Law Nerds. So fun story. There's a motion to continue on the docket and a few other motions on the docket. And so I'm not quite sure what's going to happen in court tomorrow. So we will either be covering a hearing or we will be pivoting. Pivot. We will pivot. So today is half and half. We are half doing what we're supposed to be doing and half pivot. So today we are covering a brief hearing in court, and I am going to be the spoiler alert today. I'm the spoiler. No one testifies. We're going to go over what comes next. We're going to go over the next date. We're going to go over that hearing either way. We're going to talk a little bit about a hearing yesterday in Massachusetts. Proctor still wants his job back. We're going to talk about Alan Jackson being on the morning radio this morning, talking about being on Karen Reed's civil case and some of those filings from yesterday. So we got just a short hearing, but I wanted to realistically set expectations. Let's see what they do. We've got a short hearing and then a lot of other things to cover. So we're just going to do it all today. And thank you all for your patience. G was having tech issues today, which caused everyone to be deeply frustrated at my house, but we got it sorted before I was streaming because, well, mom life, summer life. Sometimes it takes everyone in the household to fix whatever is going on. So that's what we were doing this morning. So I appreciate it. It's just, look, life is dynamic and summer is summer, but next week, everyone will be back at school, and that will be a whole different thing. Emily, is Travis supposed to be back in school this week? Yeah, but he has DCI finals, and his school has been incredibly supportive with it. So it's, mom life, streamer life, all the things. But we're going to go to court. I'm going to roll the intro. We're going to do all the rest of it. And it's a very Monday, Tuesday for me. I haven't even had my coffee yet. Let me know where you're coming in from, what you're drinking, because this cappuccino is singing to me. I need it more than I care to admit. That's not true. I am not shy about my caffeine dependency. It just is what it is. Law Nerds, we are going to go to court. That's the first thing we're going to do today. So at least with that, we still get to go to court. So yay. Live court, here we come. I'm going to roll the intro. Let me know where you're coming in from, what you're drinking. Let's ride. Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. Yes, we need to get to court. 100% we need to get to court. It is exactly what we need to do. I feel like, though, maybe we need to fly to Massachusetts. I feel like we need just the whole thing. But the upside is NBC 10 Boston was in court, so we actually have a camera in court, which is really helpful. So, I don't know. Pack your bags. I feel like we just need to do both today. Why? Because it's a Monday, Tuesday. I didn't even say what day it was when we started the stream. It's Tuesday, August 5th. I just try to keep us in order with where we're at. I don't even know. Let's go to Massachusetts. I think everybody today was like, this is just gonna go. And after seeing the docket last night, I was like, this looks exactly like a continuance in the making, which is so annoying for everyone and happens all the time. It happens all the time. Continuances are such a normal part of court. And now that the defendant in this case is out of custody because of all of this that's been happening, the courts, well, it seems like the courts aren't, I can't even say the courts are going to be more accommodating to continuances, because it seems like the court hasn't been putting the fear of anything into anyone, because the court's just been like, oh, okay, what's going on? I'm still baffled by this case. So let's talk a little bit about what we're going to court in. It is a homicide prosecution. The defense attorney that we will see in court is the defense attorney for Myles King. There's also a co-defendant in this case. The allegations here are all surrounding a pending motion to dismiss, centered around failing to disclose discovery. We will get into the failure to disclose discovery a little bit more today. That motion, when it was filed, is like 40 pages long. And the Commonwealth also agreed to the continuance. Why? Because there's a new DA on this case, not Adam Lally, who had the case originally. And the new DA on the case seems to acknowledge that all of this is just ridiculous. But for years, Adam Lally did not turn over a discovery. And when we watched the last hearing, which we will link down below, when we watched the last hearing, he was like, I mean, they'll get it eventually. Discovery is an ongoing obligation. First of all, that's not what that means. That's not what that means. Discovery being an ongoing obligation means that if something new comes in, you are still obligated to turn it over. Like, just because the discovery deadline is passed, if you receive something new, you still give it to the other side. It's not like discovery ends. New things mean new disclosures. It doesn't mean turn it over whenever you want to. That's not what it means. And it seems that everybody's been rolling with, we'll turn it over appropriately. No, you won't. We'll turn it over eventually. Part of the fault I find in this is not just the district attorney's office for not doing their job. It is ultimately the district attorney's responsibility. And if law enforcement is not giving things to the district attorney, it is the district attorney's job to escalate it. If it needs to be escalated to the court, you go to the court. And then you say, I need a court order. I need a court order. No one's giving me what we're supposed to do. There are processes and steps you can take as an attorney to try to get things turned over. You don't just wait 3 years and go, meh, it'll be fine. So the district attorney is responsible for forcing law enforcement to do their job. Should law enforcement just do this? Yes. But if they don't, it then goes to the DA. And if the DA is not doing it, it then goes to the judge. And I don't know how anybody's gone this long without turning over discovery without sanctions. And the problem is, we might now be at the point in time where the sanctions that are appropriate to remedy the situation means that a murder case gets dismissed, which I can't imagine how devastating that would be to a victim's family. It's like, hey, this thing happened to your loved one or your son, your brother, your friend. And the person that we have charged with doing that thing isn't going to go to trial because no one did their job. It's incredibly frustrating. And so my level of annoyance is high with this because it's A, not that hard. B, they went to a grand jury, they had this shit. It's not like they don't have it. They have it. Turn it over. And C, the attitude threw me sideways. Lally's just, I requested it. The lack of giving a shit is so incredibly frustrated. And a lot of people deal with burnout at work. I don't know if this is just his default setting. I don't know. But when you have a job where you are responsible for whether or not people go to prison, you have to handle yourself so that you can handle your work. You have to. And your work has ethical obligations. And you have to handle those. So all of it is frustrating. I'm trying not to just rage at you on a Tuesday morning, but I don't have words for how wild this is. And I gave a lot of grace in the Karen Reed case, and in hindsight, probably too much. Going, maybe this is law enforcement not telling him. Maybe this was an error. Maybe this is just this case. Doesn't seem to be. So my level of frustration keeps increasing because it seems that this is the default setting. And that's completely unacceptable. This can't be the default setting. And I'm sure the defense attorneys feel like they are just screaming into the void if the courts aren't doing anything. Because at some point, if this is the pattern for the district attorney's office, it is the job of the courts to step in. And if the courts won't step in, well, then we end up in a second retrial in the Karen Reed case. That's where we end up. That's where we end up. Because do things go sideways in cases? Yes. But nothing should go this sideways. I don't understand how you have a search warrant or 6 search warrants at a minimum that you use in a grand jury and then those don't just get turned over. Like, I can't understand a circumstance where that just like happens. Apple Jam and PB, we're going to talk about this tomorrow, or we're going to talk tomorrow. No, Emily, today. We're going to talk about this today. Proctor's lawyer said yesterday that they had received 5 records out of the 269 requested. It seems like the default setting. Look, I'm trying not to play picky choosy with my rage, but also, well, Proctor, it's real frustrating when you don't get the discovery, isn't it? Like on this one, I'm kind of like, I mean, maybe you need to know what that's like. He should get the discovery too. Legally, he is entitled to it. He is entitled to the discovery. But as Linda D said, how the turntables turn. So yeah, I'm going to be a little bit petty about that one. Lawyer Emily says, everyone's entitled to discovery, no matter if they're going through a civil service process, no matter if they're going through a criminal process, there are processes for these things, follow the process. But a little bit of me is like, oh, isn't that rich? Isn't that rich? But Your Honor, we don't have discovery. Really? Frustrating, isn't it? It's like, how can anyone even treat you fairly if they don't give you the discovery? It's like that, huh? So weird. That must be incredibly frustrating. Poor you. Must be hard. Must feel like everyone's just not doing their job and everyone's against you. It must feel really unfair. It must feel like there's this whole system just working against you. And there's nothing you can do because your lawyer asked for it. And then everybody just goes, we'll get it eventually. Yeah, that's rough. That's really rough. You know what, Proctor? You can have a continuance. Oh, wait, that means you still don't have a job and you want to get your job back. Well, you can just, you're not sitting in custody, so you can just have a continuance. You can just do it later. You can just put it over for a few months. They'll just get to you eventually. It's going to be fine. We'll get to it. Becky RN said in the chat, your rights are preserved. 10 out of 10. 10 out of 10. 10 out of 10. It's true. Melamo said, let's talk about this in 3 years. Right? It's only been a few months. Lucy in the chat said, I'll allow it. Yeah, you'll get discovery. Kristen in the chat said, Proctor not getting discovery feels like karma. Katie K in the chat said, have to pause to do the light testing for my EEG. But now the tech is so invested, he wants to listen too. Hello, KDK and your tech. Don't worry, replay crew. We're going to be here for a very long time. And we're going to hear more about discovery fuckery. We're going to go to court in just a minute. The other Aaron said, I'm in full petty university here. We've even summoned Swoop. We've summoned the petty university. When Law Nerd University and Petty University let you do like exchange classes. We're going to just make the campuses delightful with lots of quiet, plush, comfy spaces to study. Pick your vibe. Like cottagecore vibe, like plushy, bougie, padded room vibe, which I love when everything's just soft and you can just lean against the walls. Minimalist, like pour over coffee vibe. Pick your vibe. But yes, we can do some dual enrollment. Katie said credits transfer. Perfect. Yeah, we can work it out. Kelly Chloe Bits So We Quit said that is the full screen name. Such a shame there isn't a violin that is that small. Actually, one of the law nerds sent me this. It's not the tiniest of violins, but it is fairly small. I just feel like we just, I just feel like we do have a little bit of a vibe. There's also a trombone, I think, but yes, it's a keychain because you never know when you might need it. But it's such a shame. It's such a bummer. It's such a bummer. Really is. Everyone has the right to get their discovery in a timely fashion. It's the only way you can make a defense. How can you make a defense if you don't have the discovery to know what you're doing? I bet it feels really challenging. Maybe some deep breathing. The continuance will be fine. Go take a walk. You'll be good. Let's go to court, shall we? I mean, look. Isn't it strange? We're going to talk about Proctor trying to get his job back in a little bit. We're going to go to live court. I mean, it was live today. I'll allow it. Live today counts as live court. I'm glad that Boston 10 was in the courtroom. I hope we have closed captioning, that we've waited long enough to have closed captioning. But part of the reason I did not stream when court started is because I was pretty confident that this was probably going to get continued. And I wanted to give myself a little bit time to literally pivot and grab some more documents. Helena Brainerellis in the chat said, isn't it ironic? Don't you think? I'm here for the Crimea River. Oh, y'all are bringing the lyrics today. All right. Back in a courtroom you may recognize on the record in the Myles King case, which is really the continued fallout of what the fuck is going on in Norfolk County. I mean, that's really why we're here. We're here for what the fuck is going on in Norfolk County. And it kind of feels hard to look away at this point. I don't know if this case will go to trial. I don't know when this case will go to trial. I don't know if this case will be televised when it does go to trial. The discovery issues are really staggering to me that it is this bad. So here we are. I will look at the Walsh case probably after the Adelson case because that one's a little further down the road because other stuff's going on with Donna, but we will take a look. All right. I have not watched court yet. I know that they continue it. I don't know anything else. So other than the ultimate result, thank you for no spoilers. Oh, Emily, where's your notepad? I got it. I'm still deep in the middle of trying to figure out a new and preferred workflow. Don't worry, we'll probably do an entire members only live about all of the adventures. Once I don't want to pull you in the middle of the adventure until there's an answer, because that's the worst. It would be like, what are we doing? Yes, I know. So we're busting out the Remarkable, which is, as far as note taking goes, my absolute favorite for note taking. PDF reading, not my favorite for that. We'll talk about it. All right. Michael J. Money said, driving from Las Vegas to LA right now, and so grateful I get to do it with EDB and the Petty U alum and students. I love it. And yes, I have done that drive more than I care to admit. And I'm not even like the Vegas person, but it was just fun to be in the city that never sleeps as an ADHD night owl. But then I would get overstimulated and be like, I must leave now. Adult Vegasing, I like shows and generally food and shopping. I am not always a gambling folk. I rather gamble on whether or not I'm going to like the purse I just bought. I do love a penny slot, though. Those are very fun. Like the video games with real money, those are kind of fun. But I love a restaurant. I love a show. I love a dueling piano bar. The one at New York, 1010. Love a dueling piano bar. How long does it take to drive from Las Vegas to LA? Just curious, because I don't know. It depends on time of day, tolerance for speeding, and whether or not it's like a Baker to Vegas weekend or like a giant show weekend, because you can get stuck in some pretty gnarly traffic. Wow, Emily, you've never sounded more California in your life. You can get stuck in some pretty gnarly traffic. But if you're not in traffic and you're not worried about speed traps, it just depends. Depends on time of day. But roughly like 4.5 hours for a normal non-trafficked situation. Let's go to court. Also, for all of the members that were on our tech test, I know I'm very excited. We're going to be trying things. We're going to be trying things soon. All right. Let's go to court. Let me know how the volume is in the chat. Thank you. Let's roll.
Sullivan, who represents.
It's mono. There's nothing we can do about that. It just is on my end. I am hoping that by the time it gets to your end, it is not mono. But if you only have one headphone in and you're like, I don't understand what's happening, it might be that it's coming through mono on your end too. I'm hoping it converts, but it doesn't always. So that is my one caveat. If it feels like you can't hear, you might have the wrong earbud in.
The Norfolk County District Attorney's Office. I had a conversation with the Assistant U.S. Attorney LaMacchia. My biggest concern is whether or not.
I don't know if she's actually talking about the Assistant U.S. Attorney, if there's federal things going on, but it sounds like there's probably federal things going on.
Sullivan, who represents the Norfolk County District Attorney's Office. I had a conversation with the Assistant U.S. Attorney LaMacchia. My biggest concern is whether or not it's been communicated to the U.S. Attorney's Office and or the federal judge that you and Judge Fournier and everybody else are looking for this February 2024 order. When I had that conversation with Assistant United States Attorney LaMacchia, he didn't indicate that there was a conversation one way or the other. What he said to me is he needed to speak to Mr. Sullivan, and then he would get back to me. When I called again, I didn't get something affirmative in terms of, is that being discussed amongst the things that need to get resolved? Because this court has made it clear that you're not inclined to make a decision on my request for discovery until we get that order. And I just want to make sure we're not waiting until next week, and then all of a sudden someone says, now we need the order. So to the extent
look. I would like to see the February order.
And I conveyed that to them.
But I also have to deal.
This is a continued hearing on the hearing we watched together. This is a continued hearing on discovery issues. It is the evidentiary part of a motion to dismiss. So they are taking evidence about what's going on. I need to look into more what's going on with the federal whatever, because there is a federal part of this. I don't know what that is yet. We'll figure it out together. I am focused on the discovery issues that might cause this case to get yeeted like the Baldwin case did. The defendant has been accused of murder. He was in custody with no bail, which is not uncommon in murder. He was in custody, no bail, for 3+ years. He is now out of custody in part because of these issues. it seems to me the district attorney's office now, and you see the back of Adam Lally's head, he's in court. It seems to me the district attorney's office is trying to mitigate so that the court will say, okay, there may be violations here, discovery violations, Brady violations, et cetera. There may be violations here, but it has been remedied before trial, so the case doesn't need to get thrown out. It seems that they are trying to save this from the most extreme remedy, which is the case being thrown out. Somebody being released on substantially low bail pending a murder trial is a pretty strong remedy of saying, look, the delay is the delay. So, yes, for those of you in the chat that have already seen it, I have not watched it yet. We have not watched it together. Thanks, just Rhonda. This is the best attitude. Like, ooh, we all get to watch together. And for those of you that know what's coming, you get to sit there and be like, ooh, we get to watch together. So that's what's going on. I'm going to cover that motion a bit today, later, that motion to dismiss. We're not going to cover all of it. It's 40 pages. We got a lot to cover today. And we're never going to get through it if I don't stop pausing.
With the issue of whether, regardless of what the order says, whether there's still a constitutional obligation on the DA's office to review the information that they are in possession of to determine whether it contains exculpatory information that should be produced in other cases. In other cases, I appreciate the fact that somebody says you can't look at this or you can only look at it for a limited purpose, but I'm not sure that that trumps the constitutional obligation that the DA's office has to review stuff. I'm trying to avoid having to decide that if we can get the authorization from the federal court so that we don't have conflicting orders, but we're not there quite yet. We need to run it to ground a little bit more, and hopefully we can get some movement this afternoon. I think I told everybody last time, out through the 11th. So I'm back the 12th. I'll see you the 12th. I'll see you the 13th. Whatever is convenient for everybody to get back together. I think...
Judge, I appreciate that.
Excuse me, Your Honor. Will I see you in Indianapolis for DCI finals? Are you a DCI fan, Your Honor? Because I'm also out till the 11th. So the 12th is perfect for me. I wonder if, and a lot of you have said in the chat, this is my speculation, I need to double check. I also wonder if this is about Proctor's texts, because Proctor's texts came from the feds and are sealed. And we know the feds have all of Proctor's everything, but if it's not related to this case, it doesn't get turned over. Like the defense attorney in this case doesn't get the see you next Tuesday texts from Proctor in this case. So what would need to happen, and it sounds like that's part of the conversation, what would need to happen is that all of the discovery, if there is any from the feds that are sealed, that would all need to be reviewed for anything specific to this case, this defendant, and then those parts would get turned over only. And you can understand where the pressure and frustration is from the defense attorneys being like, I don't trust any of you. I would want the court to review it in camera. The court's not going to do that. The court's not going to review every document. You have to hope that the feds will know enough about this case to know if it's about this case. And that's difficult too if you don't know the case and the people involved. So I think this is probably about Proctor's texts. I think this is more fallout of the Proctor problem. Mitch said, wait, there's see you next Tuesday texts in the Karen Reed case. But yes, essentially they need a taint attorney to go through those, but the feds have to allow, they're sealed. So the feds have to allow part of that process. So we seem to not be at the point yet where the feds are allowing that. That's what I'm gathering from coming in kind of mid-statement. This is the earliest in the hearing I could find. This is not a different judge, same judge, different camera angle, because there's a camera in the courtroom versus over Zoom. If you can see above Jim's head, there's that little webcam. That's what we were looking at last time. Continuing on.
100%. My concern is if we know that we're running up against that clock that runs out on the 18th of August, is there a way that the government can now, or the Commonwealth can now ask the government to extend that order again? I don't want to be in a situation where you finally make a decision.
I think the Commonwealth understands that. So.
Yes.
And I invited you the last time to seek to intervene or to do whatever you needed to do to communicate your concerns to the feds.
I understand that, and that's what I did, Judge. I had a conversation with the U.S. Attorney's Office, had a conversation with their attorney, and the plan was if we did not hear back in a way that was reasonable to us, both myself and Attorney Sullivan planned to file a motion on Wednesday to intervene.
Okay, great.
That was what we were planning on doing. So that's before we knew that they weren't going to have a meeting until 4 o'clock on Tuesday, Judge.
Yeah. All right. So do you want to set a date? Do you want to say the 12th?
I think the 12th at 2 o'clock, just from my reading of the emails that was going around yesterday, seemed to be the best.
I think that's what Ms. Irwin said.
Sure. Yes.
Okay. So we'll put, let me just see, we will put.
Except for Mr. Wester, I do want to say, who will still be on vacation.
Right. We will put King, De Los Santos, Johnson, and Chanchillo.
That's a lot of cases.
And I think also Walsh.
Yes, please.
On for 2.
Did you hear how many cases that was that are all dealing with this issue about the feds turning over text? A few of you asked this. Tracy V, it's a great question. A few of you asked, how can Lally be sitting there? There's nothing in here that goes directly to Lally's testimony. This is actually stuff Lally can't turn over. This is not Lally's fault. This is dealing with the feds. It seems to me now that we've gotten all these other cases, this is dealing with the feds texts about, or Proctor texts, which every defense attorney in the state is like, no, I'm going to need those. He was investigating my case at the same time. So Lally's in there, but this is not something Lally has control over. This is actually not on him of all the things. This is part of Proctor's issue. So I'm going to back this up because the court just put over a bunch of cases for that day.
Sure. Yes.
Okay.
And that gives you a sense of how many cases are going to be heard about this.
Emails that was going around yesterday seemed to be the best.
I think that's what Ms. Irwin said.
Sure. Yes.
Okay. So we'll put, let me just see.
Listen to how many cases this is.
Except for Mr. Wester, I do want to say, who will still be on vacation.
Right. We will put King, De Los Santos, Johnson, and Chanchillo, and I think also Walsh.
Yes, please.
On for 2 o'clock on the 12th. On the issue relating to the federal Proctor discovery.
Yes, Your Honor.
Oh, well,
Okay.
there it is.
And is there any way to get an update from the 4 o'clock meeting today, Judge, so that we're not waiting until the 11th or the 12th, the morning of the 12th, to find out what happened?
I'm sure that the Commonwealth will alert folks to whether
You're sure they will?
progress has been made. Everybody.
Are we confident? How can we be so confident? I'm not How are you confident? I'm not confident. The federal Proctor discovery. Whoop, there it is. So 1, 2, 3, 4, 5 cases that are Proctor cases waiting for the feds to disclose the Proctor discovery. At this point, I think you protective order it and turn it all over. And then you fight about whether it's admissible. Like, the shit's so far out of the horse on that. But Proctor's probably waiting for that discovery too. Let's continue on.
Thank you,
Okay.
Your Honor.
And is there any way to get an update from the 4 o'clock meeting today, Judge, so that we're not waiting until the 11th or the 12th, the morning of the 12th, to find out what happened?
I'm sure that the Commonwealth will alert folks to whether progress has been made. Everybody needs to be on the same page ultimately for the hearing on the 12th, and you're going to have to act quickly. The Commonwealth may have to act very quickly depending on what happens.
And I've been doing that.
Yeah. Okay. Thank you.
Thank you.
Thank you, Your Honor.
All right. Now, with respect to the King matter, we're just dealing with the issue.
The reason we came in the middle is because this was docketed on a different case, same issue. So they are moving to the King case now. We came in the middle probably because the person in court was like, oh, this is not relating this. And then they're like, oh shit, this is regarding this. So we didn't hear what docketed item they called, but it dealt with the King case and the Walsh case, amongst others, regarding the Proctor problem and the Proctor texts being turned over from the feds. There's a meeting happening today. And then the defense is like, we can't just keep waiting. We need all of this turned over. So now we're moving to the King case.
Of the late disclosure. And
may I be heard, Your Honor?
sure.
At the close of the last hearing, you asked the defendant to provide the court with which documents were either exculpatory or would inhibit.
This attorney is now calling back to the last hearing on this matter. He's a little harder to hear, saying the court wanted the defense to identify which of the delayed discovery documents were exculpatory or would inhibit them from moving forward. So that's what we're talking about now. So we are now kind of jumping back in time. I believe this is Lally's attorney who is, or the attorney for the Commonwealth that's doing this hearing. I don't think this is the attorney for the Commonwealth on this case, but I might be wrong, so we're going to keep watching.
The defendant's right to a fair trial would be prejudicial to him. I have not heard of one document since these have been provided in April and May. And to that end, I'd ask the court to order that right now. I think that this has gone on. This is now the second day of a hearing, and the Commonwealth is unaware of which document or which documents are prejudicial to the defendant and will prevent him from having a fair trial.
We had two things I was looking for. I was looking for that, and I was
Pause the
also...
court real quick. So the attorney is saying, look, the court ordered the defense to point out which documents they think are exculpatory or prejudicial. That is part of the standard when we're looking at Brady. I covered that when we were talking about the motion to dismiss in the Karen Reed case. The standard in Massachusetts is difficult. Griffin T in the chat said, I don't trust the DA to decide what documents are exculpatory. They're asking the defense to identify which specific documents, not the prosecution. But the defense has a lot of that discovery now. They are arguing delayed discovery. So they, of course, can't argue things they don't know doesn't exist or that they don't have. It's things that they got super late, and they are saying, look, because of how late it is, we are harmed in some way. The way that the standard reads in Massachusetts, and if you want, we will link it down below at some point. We will cover, or you can go back and watch me cover the Karen Reed motion to dismiss. The standard in Massachusetts is a very high hurdle. I am not a track human. I mean, I will hurt myself stepping out of a car. So track and field is not my jam. I don't know. It's like the difference between a hurdle and like a high jump, maybe, and like a pole vault. Like we have different standards. Pole vault being the highest, then the high jump, maybe, then the hurdles. But in Massachusetts, that standard is more difficult to clear than in some other jurisdictions. And I talked about that when we went through that case. In Massachusetts, the case law is difficult for the defense to prove, especially if they have more time. And so part of the argument is, okay, well, from the prosecution, and the court's going to have to evaluate, well, you've got it now. So if you've got it now, you have it before trial, so we don't need to throw it out. So what's the other remedy? And so part of the remedy here was the defendant getting out of custody. That was part of the remedy. But identifying we will not get a fair trial because of this is what the court asked the defense attorney to do between hearings. Courtney said, I was a pole vaulter, and that ish is so fun. God bless. It looks fun, terrifying to me. Like, I love a good diving board into some water. I do not trust myself on land. I am not well made for land. I injure myself. It looks fun from afar. I could literally never, but it looks amazing. Look, it's one of the reasons I loved color guard. Throwing shit was really fun. I liked water polo. Throwing shit was really fun. Then I tore my rotator cuff. That was not so fun. My shoulders were like, girl, no. So the court is saying, I wanted the defense to identify which things were the problem, and then the court's going to continue on.
Looking for some sort of a agreement of the parties, if it was worked out, to identify which of the documents were newly disclosed, which were partially disclosed previously and fully disclosed more recently, and then there was the prejudice analysis as to the new documents.
Correct.
So there was sort of a two-phased process. I don't know whether either one of those phases happened, whether the parties met and tried to work out an agreed list as to what was new or what was not new.
I endeavored to work with ADA Hickman to ensure Your Honor had a complete list as diligently and as best as we could of what documents were previously produced, and that was provided to Your Honor. I believe was sitting on your desk as Monday morning. It was a third exhibit that the Commonwealth provided. We did confer on Friday afternoon. It was represented to me that counsel would be providing us a disagreed list or a number of other lists to show the court what they disagreed with.
I got a pile of documents.
And we got that as well.
This is the pile that I got, I think, from...
The court is me. Look, y'all, this is what's on my desk. When the court has to stand up to go through the pile of documents, it's wild. Lori G asked in the chat, yes, isn't that the guy who read Karen Reed's verdict below the judge? Yes, that is the court clerk. This is that court clerk's courtroom. It seems that the clerks are assigned by courtroom, not by judge. And so this is the clerk for this courtroom. And the judges in Massachusetts rotate and rotate between civil and criminal, which is wild to me, but they rotate, which is common in a lot of jurisdictions, but kind of breaks my head. But it seems that the court staff stays with their courtroom and the judges rotate around, which also as court staff would be really difficult to get used to different judges and how they want different things done. But that's a whole thing. Kay said, question, do people always interrupt and talk over each other in court like this? It really depends on the type of hearing and the judge. And normally the judges will overtalk, not the attorneys. But when they're trying to sort something out, they're really just trying to sort out information and have a conversation. So let's continue.
Mr. Piccio's office, I don't know if included in there is the chart that you folks worked out that you say was on my desk. I'm not sure I know what you're referring to in terms of a list that was new or not new, but maybe it is in the stack.
It's a table. It's the third. If you look in the manila folder that's underneath that.
He's tall enough to see what's on the judge's desk.
And a rubber band. It's in your hand.
Oh, in here.
I could never.
This one.
That, yes. Third doc.
He said third doc.
Okay.
That is what I
document,
prepared with the assistance of ADA Hickman.
Okay.
Which specifically describes what, if anything, is minorly different. That was provided to counsel on Thursday last week. We met we had a teleconference on Friday, and counsel was working on their own lists.
Okay.
So to answer your question, no, there was no agreements as of.
We have a what if anything problem in Massachusetts. I think it's the least of our concerns. The list that they are talking about is trying to come up with a list of what was disclosed to the defense and when. So what discovery did the defense get? And then when did they get that discovery? And the defense says prosecutor is saying that the defense has some issue with some of the list and is going to make their own list of what they agree with and what they disagree with. The fact that they have to do this much work to figure out when shit was turned over is a huge problem.
Now, we endeavored to meet earlier and understand from my pleading what counsel disagreed with, but that was not reached. We provided you, the Commonwealth has provided you as best we can what has been previously provided.
Okay.
If there's any subtle differences, We can supplement that at a later date, but at this point, I know ADA Hickman has worked very hard to go through the material.
Attorney Scapiccio?
Thank you, Your Honor. So we've provided 3 charts, both to the Commonwealth and to the court. The first chart deals with the information contained in the Commonwealth's opposition in disputed documents from pages 7 and 8 of their motion to dismiss. The second chart deals with all of the new discovery, which I thought we were in agreement that the second chart is everything that was new, it hasn't been disputed by the Commonwealth. And the third chart is the information.
So you have 2 dueling charts, huh? So you have the Commonwealth's chart and your chart.
Yes.
This is exactly what I didn't want to have happen.
I understand, Judge.
So why didn't you get to
You know what the defense didn't want to have happen? The defense didn't want to have to sit here with 3 fucking charts trying to tell you when the Commonwealth finally turned over discovery. But alas, here we are. The court's like, this is what I didn't want to have happen. Okay, well, how do you want them to merge the charts? Do you want them to have a column that says agree, disagree? But yes, we have dueling charts. Why? Because the defense isn't going to just acquiesce to when the prosecution says shit was turned over.
together and work, figure out a...
I tried you.
Well, I think we both tried. I'm playing catch up here, Judge. They've had this information since 2021. I'm trying to go through it, organize it, and figure out where it fits in the most timely fashion that I can. And that's what I've spent my time doing. So when we spoke on Friday...
Do I have a list of the items which are new or which you claim to be new?
I'm trying to keep the closed caption where we can see everybody, but it's just not easy. So apologies to anyone's face that gets covered.
And that I can then cross-reference against the Commonwealth's list, which you say are prejudicial or are exculpatory, and you're behind the 8 ball because of the late disclosure, notwithstanding the continuance.
Yes, Your Honor.
Okay, where will I find that?
So where will you find what, Judge?
Your list of the explanation of why particular things are prejudicial to you.
That hasn't been completed yet, Judge.
Okay.
I just got to the point where I was able to send a list to them literally Monday morning saying, based on everything that you provided since April, here's what I think is new, and we all agree it's new. That's chart number 2. Here are my disputes from what you say you already gave us from the first part of your motion, and here...
I kind of love that everything's separated by pink paper. It's really making me super happy. The judge asked them to have this done before this hearing and asked the defense to have this identified before this hearing. And I don't think the judge is annoyed, or at least that's not how I'm reading it. And the judge is like, where are we with that? And she's explaining, this is how much I have been doing. And I've just been trying to figure out what I was given and when and what's the newest. And so that's what I'm trying to explain. So she's explaining to the court why it's not done yet because of how much there is to do, which I have tremendous empathy for, because this shouldn't be happening. And if the Commonwealth turned over everything with discovery receipts, the Commonwealth would have a stack of paper that would say, like, I don't know, what DA's office is, what the date is, what the court date is, what was turned over, how it was turned over, paper, disk, thumb drive, whatever. And then the defense attorney would sign it and date it. And then you would just have a list of paper. On this date, this was turned over. Because when things aren't digital discovery, things can get lost. You can also do them digitally. You can have people digitally sign them. And then you would just have a stack of discovery receipts and say, this is when things got turned over. And then you could cross-reference that. That there just doesn't seem to be a process, which I get if we are talking about a traffic ticket, but it's a murder case. I just don't understand.
Is what we say is new from the second part of your motion. That's what I was able to accomplish in the week that we had between now and the last hearing.
A week's not that much time.
So you need more time to get the other stuff done.
I do.
Okay. How much time do you need?
It depends. I just got more discovery this morning, Judge, so it just keeps happening. So in order for me to get my hands around it, they have to be able to certify that I have everything, Judge, because I can't keep doing this piecemeal the way that they've asked me to do it over the last month and a half. So do we have everything? Because if we do, I'm happy to sit down and say, this is where we are and this is where we stand.
you
But if we
even
don't
trust
have
when they say
everything,
they
and
have
we're going to come
everything?
back in a week and they're going to hand me something else in the morning of the hearing and say, this is, you
Well,
know, now this
as
is.
an initial crack, I wanted a list of what
At least it's easy to identify what's new if they just gave it to you yesterday. Optimistically. That shit's real easy to identify. This is new.
was new and what was prejudicial in the two notices as of when the motion to dismiss was filed.
Yes.
That's what I think we were shooting for. We
And that-
understood that some new stuff had been produced after that.
Yes.
And I don't know what the explanation is for that, but in any event, we're looking at what was filed as of the time the motion to, what was new as of the time the motion to dismiss was filed.
So Judge, what I did with the new information is I put it in chart 2 as just a description of it. I cross-referenced it to a bait stamp number if we had it, and I put it in a discovery category, which is I thought what the court asked me to do. So some of it has to do with jail calls, some of it has to do with social media, some of it has to do with search warrants. I've categorized it in a way that I think that I was hoping it would help the court understand.
Can we make a record here?
Yes.
These are, you were referring to lots of stuff which is not in the record.
Correct.
Right? We admitted in the last hearing exactly one document.
Yes.
Right? If you are referring to particular charts,
Yeah, those all need to be
let's be
marked.
clear about what they are. Let's mark them as an exhibit. And then we'll discuss what we need to do. You can explain
Aren't
what
they
those
docketed?
documents are to me without
they
a
not
witness.
file
I
them?
think that's sufficient. And then we'll decide whether we're going to proceed with the hearing on an evidentiary basis today or not.
Thank you.
It should be docketed.
Oh, I'm sorry.
All right, so I've been handed 3 charts. Chart 1, Chart 2, and Chart 3. You're moving their admission?
Yes, Your Honor.
Okay, any objection, at least for the record here?
No objection, Your
Okay,
Honor.
so these will be marked
these are
as,
not docketed.
unfortunately, Exhibits 2, 3, and 4, because we already have an Exhibit 1.
And may I admit the Commonwealth's exhibit? The chart.
This is the Commonwealth Exhibit.
Yes.
Any problem with this?
No, Your Honor.
Okay, so this
Fair
will be
version.
Exhibit 5.
Thank you, Your Honor.
I now need notes because this hearing is just, we're going to get just through it.
Thank you.
This is a shit show that shouldn't be happening. This shouldn't be happening. It's not the defense's fault. Discovery should be simpler than this. But when things have gotten so off the rails, the defense said, I'm trying to get my hands around all of this. I don't doubt it. It's how are you figuring out what's even happening? I am Ken Ross. Good to see you in the chat. Said, is this the same courtroom that Reed was in? Yes, it is. It's the same courtroom that the Reed trial was in.
All right, how do I deal with these charts? How do I read them? They look like you're talking past each other to some extent, that they're not, so if I look on Exhibit 2, which is the defense chart number 1, discovery address in Commonwealth opposition to our motion to dismiss. Item 1, copy of search warrant affidavit for T-Mobile cell phone, draft affidavit. What does this tell me?
So what that's meant to tell you, Judge, is that the Commonwealth is, in their pleadings, are indicating that we actually got the search warrants. We didn't get the search warrants.
No, hold on. Not argument, just what does this show?
Why isn't anything bait stamped? Just, if it was bait stamped, you could go through. Bait stamp 1 was discovered on date. Bait stamp 2 was discovered on date. The way this was turned over is part of what's making it harder. It's wild.
So, document description is received by King.
Right.
What is that? What's in that column?
So that column is what we actually received as opposed to what the Commonwealth is claiming they gave us. And it's categorized.
So vis-a-vis what they say they gave us.
So the
what
Commonwealth
we
is
have.
claiming, so for the first 2, Judge, if I can just show you. For the first 2, the Commonwealth is claiming that
Sorry, Sue.
they already provided those search warrants to us. They haven't provided the search warrants to us, Judge. In fact, what they provided to us was,
No. Just slow down. I want to understand what
He doesn't understand the charts.
Exhibit 2 shows.
so Exhibit 2 takes the Commonwealth's opposition.
What's in column 1?
Column 1 is the description that was received by us
You're
from the
quoting
Commonwealth.
something from what?
Discovery notices, Judge.
Draft affidavit for search warrant 21 SW. I'm sorry, you're quoting what?
We're quoting what the Commonwealth named these documents in their opposition, Judge. That's what the Commonwealth named these documents, to try to convince the court that we already had them. There's search warrant stuff down there.
He's trying to orient himself to a chart that he didn't
and
make.
you don't have any Bates numbers here, so I can't go and find these things, right?
Right, because the Commonwealth didn't have the Bates stamps in the ones that we did. So if you
Right.
look down to the second column, we do have Bates stamps. There were some things that were given.
Second column,
The second part of the chart. We were able to provide Bates
second
stamps.
chart, or the?
No, just where it says notice 4925.
All right, so how do I compare what you have to what the Commonwealth has provided me?
The Commonwealth should have bait stamped it all.
I need you to be on the same page. I need you to go through every single document
Yep.
that was produced that you base your motion to dismiss on. Every single one. You have to address every single one, okay? And you have to make a chart saying, this was produced in Discovery Packet 1. This was never produced before, okay? I don't need argument associated with it. I just need to know the universe of the problem. I need to get my arms around the scope of the problem. And then I need to know, with respect to anything that's new or substantially new or partially new, why you're prejudiced by the late disclosure of that additional information.
The Commonwealth and the defense need to sit down in a conference room for like an entire day and bait stamp everything. And the defense said, we have been trying to do this. And the Commonwealth said, we have been trying to do this. And I don't know where that's breaking down, but they have to sit down together and literally go page by page by page and bait stamp everything. And it's going to take a ton of time. And the stamping I'm talking about means that if you have police report 1 and it is 4 pages, then you have police report 1, 4 pages, and you bait stamp it 1, 2, 3, 4. And then if you have police report 2 and it's 4 pages, police report 2 gets stamped sequentially 5, 6, 7, 8, and so on and so forth, so that everything has a number in order to the case. But I understand the judge's frustration. I don't think the frustration is well placed with the defense, but I get the frustration of how do we even get to understand the problem if we can't even understand the documents? Pri asked, is this taught in law school? No. This is all part of practice. But the DA's offices know how to do this. This is not hard. But the court is just like, I have 5 charts in front of me, and I cannot sit here for an entire day and try to figure out if you're calling this document this and they're calling this document this, if those are the same document. I don't know. But that's not because the defense didn't bait stamp everything. However, it's the defense's motion. So the responsibility for this motion does fall on the defense. The problem was caused by the Commonwealth. But the motions being made by the defense, so the requests from the court are the defense's responsibility. All right, let's continue on.
Information.
Understood, Judge.
So I don't have that here, right?
I thought you did. I understand now you don't follow it the way that I followed it.
Well, I don't understand it. So I need you to explain to me why you think I do have that, if I do.
Well, I think you have part of it, Judge. I don't think.
Because her brain, this makes sense. And in the judge's brain, it doesn't make sense. Which, if you've ever been at work and somebody's handed you a chart of something and you're like, huh? That's what's happening here. The court's like, I don't understand. And she's like, it makes sense in my brain. And he's like, it doesn't make sense in my brain. The part of being a lawyer is you have to try to make it make sense in the judge's brain, which is hard to.
Give all of it.
All right. So I need all of it.
Okay.
Okay. So I understand the scope of the problem, and then I can analyze the question of prejudice. After you've analyzed the question of prejudice.
Yes, Judge.
So how are we going to do this?
Right. How do we?
We're here at 9:24. I'd be happy to meet with the parties downstairs for the next 3 hours.
I think it would be a much more productive use of time than putting Mr. Lally back on the stand.
Boo!
Or anybody else. Because there are real constraints.
The court's not wrong. But boo! The court's like, we can't even talk about what documents are a problem if we can't just talk about which documents are what. And because it doesn't seem to be bait stamped, you can't just say pages 1162 through 1190. So if the Commonwealth calls it police report X, because all the police reports are going to be under the same number, or police report dated this date, if there's 4 reports dated that date, how do you even know which one? I get where the court's at. The court is trying to make things go faster later, because otherwise someone's going to be on the stand and they're going to sit there and fight over all of this. The frustration is that if the Commonwealth had just done this in the first place, we wouldn't be here. But if the Commonwealth had just done this in the first place, we wouldn't be here. So now it's trying to figure out what to do with the shit that's out of the horse. And they've blocked aside till 2 p.m. for hearings today. Brittany Phillips said, "But Your Honor, I can't do my job if the Commonwealth doesn't do theirs." Whatever. 100%. 100%.
On the court's ability to provide a remedy beyond the remedy that has already been provided, absent real showing of meaningful prejudice.
I'm going to back up real quick. This is, I am guessing, Lally's attorney sitting next to Lally. We'll talk about that in a minute. So I'm backing up because Lally's attorney was talking to Lally, but the court is asking the defense to evaluate this hearing and to evaluate the questions. I need to know what documents are the core of the contention, because some things, even if it's late discovered, if it's been discovered now, it's not going to be as much of a problem. So I want to focus the hearing, and that's legally proper. I want to focus the hearing on the documents that are the core of the problem. And so the court's trying to rein it in so that the hearing's the core of the problem. Lawyer Emily gets it. Sitting here watching this unfold, Emily is like, put them on the stand, ask them fucking everything. That is not the legally proper result. Even though it's the result I want after watching all of this. I'm here like full Bethany Frankel mention it all. But the court is going, I have an evidentiary hearing that needs to be narrowly tailored to the documents at issue. That is correct. My desire is mention it all.
And then I can analyze the question of prejudice.
So I backed up a little bit.
After you've analyzed the question of prejudice.
Yes, Judge.
So how are we going to do this?
We're here at 9:24. I'd be happy to meet with the parties downstairs for the next 3 hours.
I think it would be a much more productive use of time than putting Mr. Lally back on the stand or anybody else. Because there are real constraints on the court's ability to provide a remedy beyond the remedy
you're right.
that has already been provided.
Emily, stop pausing. I can't today. Emily, chat, you're right. I totally forgot I added.
There are real.
Your Honor, I totally forgot I added Bethany to the soundboard. I completely forgot.
Mention it all. Mention it all.
Thank you, Danielle. I totally forgot I added it. It comes up so much. Yeah, I know that I did. The court's not wrong. I just wanted to see everybody testify. So, the court's not wrong. Lovely asked a great question in the chat. Lovely said, why not just turn over all of it? They did turn over all of it, they say. The problem for this hearing is that when it was turned over is important, and then exactly which documents are at issue is important. And the court wants them to narrow their focus. Emily, what do you mean butts and seats isn't the rule in the rules of evidence? Rainbow 910A, 10 out of 10 reference. And yes, BIS is adhered to more strongly than the rules of evidence in Massachusetts seem to be. There is supposed to be a date where the Commonwealth certifies that they've turned over all evidence. And that if something comes in late, it's a deal. Or at least it should be. It seems to me that not enough courts, this is just personal opinion, based on vibes and the cases that we've watched. It seems to me that not enough judges have said, that's late, it's not coming in. That's late, it's not coming in. There has not been enough incentive for the Commonwealth to do this. It seems that there's no consequence of saying we certified all discoveries turned over and then shit keeps showing up. Courts have to put their foot down and say, yeah, no, too bad. Too bad. If the car didn't hit, said, why is he not making them certify it now? Because I don't even know if they've turned everything over at this point. It's wild. So we're going to continue on. Kristen, I have your comment. We're going to get to it when I pull up the documents.
Constraints on the court's ability to provide a remedy beyond the remedy that has already been provided.
The court is trying to get this tailored down.
Absent real showing of meaningful prejudice. And so I need to understand where that prejudice is coming from.
I'm going to back this up. Listen to what the court said. This is the heart of what the court is asking for. The standard in Massachusetts for motion to dismiss is incredibly high. That is the law. I will link again when I went through it on the Karen Reed case and went, this is a very high standard. The court is trying to narrowly tailor the defense arguments in their motion, because this is about the defense's motion. They bear the burden in this motion. Their motion to show not just that things weren't turned over, that seems to be proven, but that some of the things that weren't turned over materially prejudice the defense. And the court is saying, can you show me which ones fall into that second part? And so the court is trying to narrow that down, because the court is saying you are asking for a remedy beyond the remedy that's already been extended. The remedy that's been extended is that A, the defendant is now out of custody, and B, the trial's been continued to get all of the evidence before it goes to trial. So the court is saying you've already gotten like remedy part 1. What do you need from remedy part 2? And that's the inquiry that the court, at the heart of what the court has to decide.
To provide a remedy beyond the remedy that has already been provided, absent real showing of meaningful prejudice. And so I need to understand where that prejudice is coming from. And it's, so you're welcome to spend the next 3 hours doing that.
Sure, Your Honor.
Okay. I know everybody's here. I know we have witnesses here. I'm
Yeah, I
sorry
see the
about
witness in
that,
court.
but I think we need to do this in a logical order.
Thank you, Your Honor.
I have a hearing at noon, from noon to 1, where I have to finish an evidentiary hearing in another 2 co-defendant case. That'll take me from noon to 1 o'clock. I'm happy to see you at 2 if you're able to make substantive progress between now and then, or I'm happy to just see you on the 12th.
I don't
But
know
the
where-
12th would not be for evidence. It would be for an explanation of the analysis that you've done
What?
on all the various documents that were apparently produced late.
I don't know where we'll get it. I mean, we could let the clerks know if we could
I'm happy to report back at 2, Judge, if that's what you want us to do.
Yeah. But I would like to release the witnesses.
Yeah, I think you should release the witnesses. I think and I think, frankly, I should see you on the 12th, because if you're not done by 12 or whenever today, we're going to be together on the 12th. It's the soonest I can see you after today in any event, and it'll allow you to do the prejudice analysis, because that's the first part of it. That's great. Everybody's on the same page as to what's new. And then I need to hear from defense counsel document by document as to why it's prejudicial that this was lately disclosed.
Yes, Your Honor.
Your Honor, if I may, I believe
That's a
we
lot
have one
to
outstanding issue that was brought to the court's attention, and I believe Attorney Moynihan is here.
So what the court is saying to them is, look, I need you to go through document by document what the prejudice is. If there's no prejudice that can be shown, then the remedy has already happened. So the court is saying you've already gotten part of the remedy. You are asking for the most extreme part of the remedy. So we need to go document by document before we even get back into witnesses. Let's see what he continues to say, because we've got more hearing to go.
We had the order of Judge Doolin of June.
Allison's in the chat asked, so just to be clear, prejudice can't just be it was late. Correct. Because late has been remedied. The court has said late has been remedied. And here's how late has been remedied in this case. The trial got continued and the defendant was released from custody. That is how they are remedying everything being late. To go beyond that remedy, defendant let out of custody and the trial getting continued so the defense has time, then you have to show that there was material prejudice. In a lot of cases where there are violations, the answer is so you get a new trial. Even on appeal. On appeal, you go up, hey, we didn't get this evidence. The appellate court says, you know what, you're right. The remedy is a new trial. So most often, the remedy is the trial. The trial's been continued. He's been let out of custody. So now they are asking for the remedy that the case gets dismissed. That is an incredibly high bar in Massachusetts. So the court is saying, show me exactly what documents or items of discovery have prejudiced the defendant that can't be fixed at trial now that you have them. And he's asking the defense to narrow down everything that's late, because it seems like there's more that's late than not. Narrow down everything that's late, and then we'll focus just on those documents. So that's what the court is talking about. The bar in Massachusetts on this, when I was reading the case law on the Karen Reed case, I was like, ooh, that's a lot. But in this motion, the defense bears the burden. That doesn't mean that the prosecution should continue to fuck around with discovery. But the remedy for the defense, beyond the trial getting continued and the defendant getting out, is tough. Okay. Continuing on. Kristen, you're at the heart of the issue here with this astute question. Kristen said, what stops the prosecution from turning over late if there's no consequences and it creates so much work for the defense? This is the problem. This is 100% the problem. I think we need to see courts not letting the prosecution use the evidence that they turn over late. I think that is allowed. And I think if the courts told the prosecution, look, you have to show me incredibly good cause, and I would need to do a deep dive into case law in Massachusetts. You need to prove why this came in so late. It's lost in somebody's fucking file does not count. You need to show me why this is so late or you can't use it at trial. They need to keep it out of trial. And that means that some people who might be guilty might not be found guilty. But the courts have to hold them accountable. Melissa said Baldwin's case was thrown out so easily. The standard in New Mexico is a much easier standard for the defense to meet. So the case law in New Mexico, when we talk about jurisdictions being different, jurisdictions are incredibly different. New Mexico had some of the, friendly isn't the right word, but I think it makes the point, some of the more friendly laws and case law for the defense. I have not seen a jurisdiction with as many protections at like grand jury for the defense as they have in New Mexico. And so when we were looking at the New Mexico standard is incredibly different from the Massachusetts standard. The Massachusetts standards puts quite a heavy burden on the defense. The New Mexico standard shifts that burden pretty quickly during trial to the prosecution. The stage of the case is also very different. Coming up in trial, different than coming up after trial. So it really shifts jurisdiction by jurisdiction. Even the things we saw in the Karen Reed case, and we went through it. The court's like, well, you're getting a new trial. The remedy's a new trial. Here's your trial. Have your trial. And I wonder if when we get to all of this, the court is going to say, have your trial. I think it would help disincentivize the DA's office if courts were keeping this evidence out of trial. That is the thing that changes the behavior. Fine, this was all turned over super late. You can't use it. That's how it's fair. That's how you remedy it. You don't get to use it at trial. That is a remedy somewhere in between dismissing the case and just continuing things forever. But if the courts are routinely just continuing things forever, the prosecution's like, I mean, there's another trial right behind this. I'll just do that one. And we'll turn over this when we turn over this. NBD. Because for the prosecution, it's like trial A, trial B, trial C, trial D, whatever seems to be the attitude. And if the courts are like, okay, the remedy is that the defense gets more time, that doesn't really slow things down for the Commonwealth. We're like, all right, maybe it'll plea. They got to keep the evidence out more. That's the only way to kind of undo this culture. But it seems like this is incredibly common. Nobody's frustrated from the prosecution side. The defense is clearly frustrated. All right, let's continue on.
17th relative to Mr. Proctor's personal phone, and Attorney Moynihan.
Oh, I'm going to back up as we start to talk about Proctor's personal phone. Hold on. You have my attention. Let's talk about Proctor's personal phone.
Document by document as to why it's prejudicial that this was lately disclosed.
Yes, Your Honor.
Your Honor, if I may, I believe we have one outstanding issue that was brought to the court's attention, and I believe Attorney Moynihan is here.
We're none.
We had the order of Judge Doolin of June 17th relative to Mr. Proctor's personal phone, and Attorney Moynihan has filed a motion on our last date relative to that order, and I wondered if we could address that today. It's the one outstanding issue that we have on Judge Doolin's June 17th ruling relative to Mr. Proctor's personal phone, Your Honor.
Judge, I didn't know we were addressing that today.
My understanding on the last date, Your Honor, is we put it down for noon because Attorney Moynihan would be here, and today would be the day that we'd be addressing this issue relative to Judge Doolin's order. I believe I asked the court on our last date whether or not this needed to go back to Judge Doolin, and Your Honor indicated that you had read the order and felt that you could make a decision.
Frankly, Your Honor, I didn't notice we were addressing that today.
Would you like to be heard on the 12th also?
This is Proctor's attorney chiming in from the back, and he kind of said, I didn't have notice. And the court's like, do you just want to come back on the 12th too? Because the counsel at the district attorney's table is like, well, we were going to talk about this today and we were going to make a decision today. The defense attorney for King said, I didn't know this was on today. And the attorney for Proctor is just like, I didn't know we were doing this today. And the court just kind of laughed and said, are we going to be here on the 12th too then? Everybody just come on back on the 12th. However, for anyone who thinks that this is unusual procedure in court, this is not unusual. Emily, why are court calendars wild? This. Because this happens all the time. All the time.
I would need to check, but if I could be available on the 12th, but that would be a better day than today.
Okay.
You want to
If I can
check?
just double
You have
check.
your calendar?
Sorry,
Do you have your calendar?
I'd have to just call my office.
Okay.
Do they not put his calendar on his phone?
Let's put it on for the 12th. Call your office.
Somebody sync that man's Google Cal. Sir, I have to check my calendar. Look, someone sync his Google Cal. A packed courtroom today.
If for some reason you're unavailable, let me know. I'll get back on the bench and we'll set another time.
Is that 2 o'clock, Your Honor?
It would be 2 o'clock, yes. I have the papers here. I didn't read them for this hearing, but I will take a look at them now. So if you decide you want to be heard today, I'll hear you on it.
I prefer the 12th. I can let the clerk know if I'm available at 2. I believe I can be available. I have to double check if I can.
Okay, all right. So if you can be available, we'll hear you on the 12th. Otherwise, let the clerk know and I'll hear you now, okay? Okay. Anything else we can do today? Thank you.
Thank you.
Thing until it's a thing. Never a thing until it's a thing.
Not bad.
So it's never a thing until it's a thing.
Okay.
What? I get it.
We're going to hang out and see if anything else happens on the record. Because who the fuck knows?
Are we going downstairs to your office? Or are we doing this here?
Just do it in court. I wouldn't want to do it in court. But the defense is like, where are we doing this with this fucking discovery? The defense attorney has to be so frustrated. So frustrated. Let's just do it now. Let's all just do it together. We'll take notes. I've never seen a criminal case need a discovery mediator so badly.
Okay, great. Thank you.
Nice job.
I mean, it's a very full courtroom. I'm going to just wait and see what happens. Because at this point, I'm curious and the video keeps rolling. So we'll just see. Lisa in the chat said, this is a terrible group project. It's the worst group project in the entire world. And it shouldn't be this hard. I don't think I've ever seen an attorney who just like came from backpacking and like threw on their suit jacket. That is, I'm curious. Are we biking to work? Like, I have so many questions. And there's no shade to that. I'm fascinated by it. I cannot. But I'm fascinated. I'm just, Emily, you're very curious about the bags people are carrying. Yes. Yes, I am.
Nice job. Nice job.
I didn't fall asleep.
Everybody seems to be clearing out of court, but we're going to watch for a minute.
No. 12.
I mean, I like Turtle Boy's bag better. No, not Lally. Lally's attorney. Though with Massachusetts, biking might be faster in some areas if the weather's nice. There were a couple attorneys that worked at the courthouse where I worked who would bike to work, and I'm like, I would die. But we know that. We knew that. We know that.
Till 12. You guys have till 12 in this room. And then I do need the room.
Oh, you can stay here till 12. I mean, at least there's big tables.
That works for
The Empress Mouse, we're going to do a summary. Don't worry. Oh, I have no problem with a backpack. I'm just curious about the different types of backpacks. But yes, I love a backpack. Emily, you love any type of bag that's new and novel. You have 3 carry-on bags for the airplane because you're Goldilocks, and this one doesn't fit your microphone stand quite right, and this one is too hard to pack, and that one is just right. Yes. Yeah, ADHD tax. I can't really know if it's going to work well for me until I try it, and then I go, ooh, hate it. And then I forget to return it. And then it's mine. But then when my kids need something, I'm like, I have a plethora. So, most of my bags are not, especially my suitcase. Look, here's the best tip about suitcases. You need suitcases that are sturdy and have a decent warranty if you travel a lot, not cute. Designer suitcases are made for private jets. They are not made for commercial airlines. Do not spend all of your money on the suitcases. My suitcases come from Target. They are all Swiss gear. They are the best. My carry-ons, my wheelie bags for my microphones and stuff, 2 of them are Toomey and the other ones are Samsonite. But my big suitcase that gets like beat to crap is Swiss gear, and they are ride or die, and they're easy to fix when stuff like a wheel breaks off or whatever. But no, you need bags that can just get yeeted, and Home Goods always has great deals on bags. Like if you can take the time to find what you need, Home Goods often has great deals on bags that are like last season's color or whatever. There's also a ton of Toomey outlets. So if you're like, I don't care what color it is, I would say pick the ugliest, most on sale color, because that's the color. Here's my secret to this. That's the color most people don't want, which means no one's bag is going to look like that. The ugliest color you can find. Paul says Emily only likes bags that are just right. I'm this way with way too many things. I've just embraced it. Mish Prop says, hey, Emily, my granddaughter is on the Spartans. She is indie bound. I know, I'm so excited. I'm having a hard time focusing. But I am focused. I'm here. I am here. I am here. They're good. Lightweight, good warranty suitcase. That works too. Luggage is one of those things that needs to be functional.
I have not, no.
I'm just waiting to see what else happens in court. That sounds fantastic. NT Pruitt said, I have an ugly blue and cream plaid one that nobody ever has. That's it. I didn't even know Wrangler made luggage. That's fantastic. All right. I think the defense probably went to do the things they needed to do, and that's the end of the case. All right. Let's do a summary of what happened in court before we get on to the rest of what we are doing today. So, Emily, there's more? Yes, there's more. We're an hour and a half into stream. What do you mean there's more? We talked a lot. I'll link the video from NBC 10 down below if anyone wants to watch it in a more smooth, less interrupty EDB fashion. So you have both options. It's all in all not a super long hearing when you take it without pauses. What happened in court today in the Myles King case? This case is undergoing a discovery battle that involves Trooper Proctor and attorney Adam Lally. The defense has made a motion essentially to dismiss the case as a remedy for the failure to turn over discovery and Brady violations, that the discovery that was not turned over is prejudicial to the defense. The court has already taken remedies in this case in that the defendant, who had been in custody for 3 years, is now out of custody on a very low bond. pending trial that has been delayed, so the defense has time to go over the late discovered and newly turned over evidence. So in continuing the trial, part of the continuance was allowing the defendant out of custody, and the court addressed and noted that remedy a few times in hearing today. Today being August 5th, 2025. The court then put a hearing over for August 12th, and that's going to be a hearing to set another hearing. Today, we were supposed to be continuing the evidentiary portion of the motion to dismiss. That's not what happened. The court said at the end of the last hearing, I asked the parties to get these two things for me. And those two things are not all the way done. So I need everyone to go get this done and come back. And the court was asking the defense of that more because it is the defense's motion and the defense's burden. So the court was asking the defense, have you compiled with the prosecution a list or a chart of every piece of evidence and when it was turned over? And the defense had a few charts and the prosecution had a chart, and the court goes, no, I want you guys to get together and figure out what each item is and when it was turned over. Of course, the problem with this is that the prosecution didn't bait stamp everything, so there's no continuous numbering system so that you can refer to everything the same. And the court's like, I need to know when things were turned over, and then I need the defense to identify what things are being argued as being materially prejudicial in the motion to dismiss. Since the first remedy has already happened, the case has gotten delayed for more time, and the defendant has been let out of custody. So what we are going to see on the 12th, I suspect, is that the court is going to have all the attorneys in, and they are going to figure out exactly what documents the evidentiary hearing is going to focus on and what documents got turned over and when, and this side quest of what's going on with the feds and Proctor's text messages, because there are 5 cases the court listed today that are waiting for the feds to turn over discovery about Proctor's phone. And apparently the feds are having a meeting today to turn over or discuss turning over that discovery. And so the defense is like, we don't know yet if we need to make a motion to intervene to get this information because we still don't have it yet. So for the defense, it's kind of like playing whack-a-mole because the defense can only address the discovery that they have. And it seems that that is now just a dripping faucet and discovery keeps just showing up. Where have we seen that before? It's just drip, drip, drip. And the defense is like, every time I think we have everything, we don't. And the court's like, okay, but we need to address what we have and what the motion is regarding and what things are prejudicial. The bar in Massachusetts on a motion to dismiss is a high bar for the defense to prove that the remedy needs to go beyond just giving more time for trial. Oftentimes, failure to turn over discovery, the remedy is either we have a trial, or if it's on appeal, hey, there's going to be a new trial. But what is clear is that in Massachusetts, the Karen Reed case shined a big old spotlight, maybe a lighthouse light, maybe that's a more appropriate analogy for Massachusetts, shined a big old spotlight on the fact that this is not just an issue in the Karen Reed case, but that this is a larger issue with discovery. And cases are lingering for years without things being turned over. And the defense today in court said there are still search warrants they don't have. At the last hearing, the defense noted that they had gotten like 1.5 of 6 search warrants that were used at the grand jury at the very beginning of the case in 2001. So this is an ongoing issue. And the court's like, I'm trying to really wrap my head around where all this discovery is, when it is coming in, when it was turned over, and WTF is even happening. But when the court listed 5 cases that are waiting on Proctor text messages, the Walsh case was one of them. We haven't talked about that case yet. A lot of you have asked me to. We will probably get to it after Donna Adelson because it's pending trial as well. But for discovery to sit from, 2021, but for discovery to sit from 2021 to 2025 and not get discovery turned over that was part of the original grand jury is wild. There's no reason that this should be taking as long as it has. Somebody has it in a file somewhere, turn it over. So today we did not see Adam Lally or Trooper Proctor testify. And on the 12th, we're not going to see them testify either. On the 12th, the judge is going to continue to try to get their hand around exactly what items of evidence are at issue for the motion to dismiss. And I have empathy for the defense trying to say, well, nothing is bait stamped. So we're trying to piece together what we got and when over years. And then we're trying to figure out what we don't have that we know we don't have, aside from the things we might not have that we don't know that we don't have. And the defense at one point said, if the prosecution's going to certify we have everything, then at least we know the dripping faucet is going to stop. And the prosecution didn't say anything to that, and it hasn't been certified that discovery is complete. I understand the frustration. I understand the court's frustration. But it seems to me, if this is an ongoing issue, which it seems to be, that the remedy is if the prosecution is not done with discovery within the period for discovery, then anything that comes in after that date doesn't get used in trial. And if you can't use it at trial, then unless you show me good cause, it's not coming in. And if it's helpful for the defense and they don't have enough time, they're not getting a continuance. Your case is getting yeeted. But it seems that the bar for the courts to make that decision is incredibly high in Massachusetts based on their statute and case law. It's an incredibly high bar. So really holding discovery that's not turned over against the prosecution seems to be one of the only ways to turn this around. But the case law doesn't have a ton of teeth to it, even if the discovery is helpful to the defense, because the remedy is, well, you can have more time to go to trial. So today, nobody took the stand, and the judge said, I need more information. And the defense attorney and prosecution had 3 hours after court today to try to sit down with their files and see what has been turned over and when, and try to take those lists and merge them so that the court knows every piece of evidence in the case, which can be thousands of pages in a homicide case, every piece of evidence and what the issues are. It's wild. Cheeky Crochet said, can the evidence gathered with a search warrant that wasn't turned over be thrown out as well? It can. It can. But that's not been what's happening. So when will we see Attorney Lally and Adam Proctor? No. When will we see Attorney Lally and Proctor on the stand in this case? I don't know. It's not going to be the 12th. So what we're going to do for the rest of the morning, we are going to take a look at the motions that have been filed in part, and then we will take a look at the interview that Alan Jackson gave this morning about Karen Reed's civil case. And we'll take a look at some of the news reporting about Proctor's hearing yesterday, because Proctor is still appealing to try to get his job back. And Proctor doesn't have all the discovery in his case to go forward on. Weird. It's just so wild. It's just a mess. But the courts are going to have to start putting their foot down for anything to change. And I can't believe the courts aren't mad. How are you not mad that all of your dockets keep getting fucked up with all of this? Somebody should be more mad, but nobody seems to have grave concerns. So, everyone seems to be rolling with it. Let's take a look at the motions that I grabbed the best I could in the underlying King case. Trying to get documents in Massachusetts is not the easiest one. It's so frustrating. First, we are going to look at the motion to limit the scope of questioning of the attorney under subpoena. This is regarding Adam Lally, and the attorney for Lally filed this. So this is part of what is going on here, and then we will take a little bit of a look. It is over 40 pages, but a little bit of a look of the request for continuance and reduction of bail that plays into the motion to dismiss that we were talking about today. So we just have a little bit of background. So let us switch to this document real quick. And if the documents look slightly blurry, it's not you. It's the documents. All of them are PNGs before they become PDFs, and they are just difficult. Motion to limit the scope of questioning of attorney under subpoena. On May 28th, the defendant in this matter filed a motion to dismiss. Again, this is the King case that we are talking about. The motion to dismiss was filed May 28th. So this was filed May 28th, and they are going to be fighting this motion until September, October, probably. This is going to keep going. Mike asked, may have missed it, but is the defendant in jail? No, the defendant was recently released on bail, but the defendant had been in jail up until June when the court granted bail. He had been no bail on the homicide case. So he had been pending no bail for more than 3 years because more than 3 years, almost 4 years. On May 28th, 2025, the defendant in this matter filed a motion to dismiss or in the alternative release on bail and continue the trial given the voluminous late disclosed evidence. We're going to look at that. After that motion was filed, the parties jointly requested the court continue the trial date and reduce the defendant's bail to $2,500 with conditions. At the hearing, the court allowed a request for continuance and set the bail at $10,000. The defendant posted a cash bail on June 27th, 2025. So that would have been when the defendant was released. The court should suspend Lally's testimony unless, it doesn't even say Adam Lally. It's just like Lally. The court should suspend Lally's testimony unless and until the defendant makes a preliminary showing as to all three required prongs for dismissal. Egregious government misconduct. These are the prongs. Egregious government misconduct, prejudice to the defendant's right to a fair trial, and a showing that dismissal is the only remedy for the prejudice. So this is the attorney for Adam Lally asking the court, which is essentially what the court has now done, asking the court to keep attorney Lally off the stand until the defense has identified which documents they're talking about and what prejudice they're talking about. And the court has said at the end of the last hearing, I need the defense to identify which documents they're talking about with prejudice because the defense bears the burden. This is the defense's motion. And the court reiterated that today and said, we need to come back and line out what documents we're talking about. John in the chat said, can the defense ask for lesser sanctions underneath dismissal if dismissal is denied? Some of those sanctions have already been granted in that the defendant who was no bail was released on bail and the trial was continued. So there have been some things that have, some remedies that have already been granted. So that's part of it. Recent procedural background. The hearing on the motion, now addressing only a motion to dismiss since the trial date was continued and the defendant was released on bail, was scheduled for July 21st. Assistant District Attorney Adam Lally, Attorney Lally, was issued a subpoena by defense counsel to appear at that hearing in this matter scheduled for July 21st, 2025 at 9 a.m. He appeared and began testifying over his attorney's objection. Well, isn't that a new tidbit? P. Lola's mom said he's out because the state screwed up. Yes. He was granted bail because the state delayed the case so much. Yes. In sum and substance, that is yes. And look, when the state doesn't do things properly, the result can be that people, and I have not evaluated the evidence in this case. I'm not talking about this case. I'm talking generally. When the state messes up, the result can be that people who should be convicted or have enough evidence to be convicted are not. The problem is, if you don't do the right thing in those cases, then you end up in cases where people shouldn't be convicted and everything's just bowling along the way the rest of it does. And that shouldn't happen either. So it has to apply equally. Skeeter says, does the continuance of the trial date change the discovery deadline date? Yes and no, but that date has come and gone, and it's incredibly frustrating for everyone because the trial just keeps getting pushed and pushed and pushed. Loudmouth said, I feel bad for the victim's family. Yeah. Because it's a constant waiting game. And wait and wait and wait and wait and wait. The July 21st hearing I covered after July 21st, but we covered that. It'll be linked below. Adam Lally appeared and began testifying over his attorney's objection. That's interesting to note. At that hearing, the court directed counsel for the defendant and the Norfolk District Attorney's Office to work together to specifically identify the scope of discovery that was disclosed late to the defense. Those are all the charts that they were talking about today that they're going to put their heads together on and come up with before the next hearing. So on July 21st, the court said, put your heads together. We'll all be back here for hearing with witnesses on August 5th. And then the defense and the Commonwealth said, we tried and we couldn't. And then they gave the court 4 different charts and the court is like, this is not at all what I asked for. Go back and do it again. And so now this is getting kicked to next Tuesday. I mean, at least it's only a week. And at least it's a Tuesday. Yay for us. We'll take the small wins in the ridiculousness of all of this. The motion from Lally's attorney said the court also directed counsel for the defendant to review the materials and identify specifically any exculpatory evidence that was disclosed late to the defense. Attorney Lally testified on July 21st, 2025, and the hearing was continued until August 5th, which is what we just watched today. With the exception that the parties would have, or with the expectation rather, that the attorneys, or that the parties would have narrowed the scope of discovery at issue and counsel for the defendant would have identified what she claimed to be exculpatory and prejudicial. Before Adam Lally's testimony recommences in the matter, counsel for the defendant should comply with the court's directive and identify how the evidence at issue here is exculpatory and how the defendant has been prejudiced, particularly given that he has been released on bail and the trial has been continued. So what the attorney for Adam Lally is highlighting here is that, hey, one remedy has already been made. And since that one remedy has already been made, we need another showing that that the evidence discussed would result in a possible dismissal. So there's a step 1, and this attorney is saying we need to do step 1 first and then step 2. The attorney goes on to say, without 2 of the requirements for dismissal under Commonwealth versus Terrapina, I didn't do this well in the Reed trial. Trepanina? Maybe? Citing Commonwealth versus Edwards, the defendant's motion fails and testimony from Adam Lally becomes unnecessary. So look, if step 1 fails, we don't get to step 2. Should the court still wish to hear from Attorney Lally, we, the undersigned counsel for him, respectfully suggest that his testimony should be strictly limited to the issue of whether his conduct constitutes egregious misconduct, which, in light of the 26 notices of discovery providing unique discovery each time, certainly does not. And then there's like a random hanging eye. But Lovely in the chat said, oh, the irony of see you next Tuesday. Literally. I will say that the volume of discovery, the fact that there have been 26 notices of discovery with unique discovery produced each time doesn't mean that there wasn't misconduct. But we gave a ton of discovery. Okay, well, if it's not all the discovery, that's a problem. And I'm still stuck on the search warrants because you had the search warrants when you did my brain just completely buffered. You had the search warrants when you did the grand jury. What takes 4 years, 3 years to turn those over? However, the court might well say, okay, but the trial's been continued. You have them now. The remedy is trial. And that's very possibly the result here, that the remedy is trial. And then again, it's, okay, so the Commonwealth just does this? And it's just like, okay, trial? I do not like the precedent that sets. The case cited by the attorney says that the new case issued by the appeals court last Thursday. Hold on. I need a note. B2, I agree with you. B2 says, but they still don't have them. Right, which you guys see the problem. All of you see the problem. All of you are frustrated by it. You're not wrong. All of you that are frustrated, like, but how is the defense supposed to argue that the search warrants and the lack of having them is prejudicial if they don't know what's in them? Yes, you have accurately spotted the problem and the frustration that we're in some kind of, awful hamster wheel of you have to prove it's prejudicial, but I don't have it yet. Okay, the trial gets delayed, but I don't have it yet. But you have to prove it's prejudicial. Okay, but I haven't seen it. Okay, well, how could be prejudicial? Well, I don't know, Your Honor. Maybe it's a Lexus that's also a spaceship. How am I supposed to know? I haven't seen it. Okay, well, if there's something wrong with the search warrants, then the evidence will just get excluded. But you still get a trial. Okay, but I haven't seen it yet, so I don't know what motions need to be made. Okay, so we'll just continue the trial. Oh, okay, but my defendant's in custody. Okay, well, we've let your defendant out of custody. Okay, but this has still been pending for like 4 years, and we still don't have the initial search warrants. Okay, but we'll just handle it at trial. Can you show us how they're prejudicial? Well, no, because we haven't seen them. Okay, but your burden is to show that it's prejudiced your client. Okay, but we don't have it. Okay, well, we'll get it. And then 5 years later, you're here going, what the fuck? I'm making a note because I want to grab this case. Or I want to make a note to myself to grab this case. At least they put in the Lexus key site. This is a brand new case, which will be interesting. I'm interested to take a look. But yes, all of you who are frustrated, yes, this is the frustration. Last week, the appeals court issued the decision. Footnote 1, this case is worth a close study. Like this case, it emanates from an allegation of late disclosure of evidence. Shock me, that there are more cases up on appeal saying, but Your Honor, we didn't get the evidence. It emanates from an allegation of late disclosure of evidence that was ultimately disclosed pre-trial. And this is why Lally is on the stand going, it's an ongoing discovery obligation. As long as we turn it over at some point, it's fine. In that case, the trial court issued an order to produce the discovery, but included what should have been an excludable time under Mass Rule of Criminal Procedure 36, ultimately leading to dismissal. The appeal court was clear that, quote, dismissal of the charges as a sanction for violations of Mass Rule of Criminal Procedure 14A1A 7, in the absence of finding of irremediable harm, was an abuse of discretion. This case is going to make it harder. Dismissal of the charges as a sanction for violation of discovery. Rule 14 is discovery. So a lower court dismissed a case for a discovery violation. The appellate court said, nah, you did not find irremediable harm. And because you did not find irremediable harm, it's an abuse of discretion. So when the court did dismiss it, the appellate court said, no, that dismissal was improper. You did not find irremediable harm. And that language, irremediable harm, most courts will say the remedy is trial. So we'll just keep continuing it. And now you understand why we are in this loop. So Emily, what is the solution? Well, the legislature would have to change the language, or the Rules Committee would have to change the language of the Massachusetts Rules of Criminal Procedure. And then the case law would have to change. Because the remedy, again, the courts are going to say the remedy is trial. In footnote 8 of the decision, the appeals court acknowledged the 2025 amendments to Rule 14, including to this, it's awkwardly written, an update including to the sanctions provision. The rule of criminal procedure in Massachusetts was updated in 2025, including to the sanctions provision, but the appellate court wrote, quote, "We discern no substantive change in this language. Rather, we think it merely provides an illustrative list of sanctions to aid litigants and judges. A dismissal with prejudice under Rule 14 still requires a showing of irremediable harm." So there is harm that can no other way be fixed, which is a very difficult showing. And it's going to go along the lines of destruction of evidence that cannot be gotten, the loss of witnesses that cannot be interviewed, those kinds of things, because then there's no remedy to that. Everything else, the remedy as you have it now, let's go to trial. But even then, in the Karen Reed case, we don't know what happened to the rest of the video. It seems to be gone. The court was like, well, no one has it, so that's fine. In order to warrant dismissal, there must be egregious prosecutorial misconduct and prejudice, both. And prejudice to the defendant's right to fair trial, and dismissal must be necessary to cure the prejudice. Drea said a witness that died, not always. It depends on the witness, what the witness would say, and if what the witness would say could be entered in any other way. So not necessarily. There's more information needed. So it really depends. Continuing on in this motion, and again, they're quoting the case law accurately. The case law is not easy to overcome. Jessica Sonny said, EDB, could irreparable harm or irremediable harm be that witnesses are going to be less reliable after many delays? No. The court's going to say that's what cross-examination is for. And if you're like, Emily, surely not. No, that's what the courts will say. That's what cross-examination is for. If witnesses are less reliable on cross-examination, it's better for the defense. Put them up on cross-examination and show that they're not reliable because it's been too long. The attorney for Adam Lally goes on to say, where the defense has not made a preliminary showing as to all three components required under Commonwealth versus New Case and Commonwealth v. Edwards, the case should not be dismissed. The remedy of dismissal is only warranted when there is egregious government misconduct, prong 1, prejudice to the defendant's right to fair trial, prong 2, and normally they say, no, it's been turned over to you now, it's fine. That's generally the answer. And 3, a showing that dismissal is the only remedy for the prejudice. In this case, should counsel for the defendant fail to identify for the court how any of the documents at issue are exculpatory and therefore the late production prejudiced his right to a fair trial, and where counsel for the defendant failed to show how dismissal is necessary to cure the prejudice given that the trial date has been continued and defendant is released on bail, the defendant's motion can be denied without further testimony from Attorney Lally. So Attorney Lally is saying, or Attorney Lally's attorney is saying, it doesn't matter what the misconduct is yet if the court finds that the remedies already given are sufficient. And the court may well do that and say, we've already found remedies and those remedies are sufficient. In any event, Attorney Lally's testimony should be strictly limited to the issue of egregious government misconduct. I don't disagree with that. The court will learn that Attorney Lally was, what did you just write? The fuck are you writing in this? Lawyers are doing their job. Lawyers are doing their job. Lawyers are doing their job. Emily, lawyers are doing their job. 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 You also have a duty of candor. The attorney writes, the court will learn that Attorney Lally was diligent, well-meaning, and his conduct aimed to conform with his obligations as a prosecutor. Aimed to conform. So you agree then that it didn't conform. We agree? You think you're pretty? It doesn't mean, it doesn't, I don't think diligence is the right word based on the testimony that we saw, but I have to just look. I give attorneys grace when they are doing their job, even when I disagree. Today, I feel like I am crazy. Maybe my caffeine hasn't kicked in. Also, I shouldn't think it's funny that the law firm name is Butters Brazilian, because I'm sure that is the last name of attorneys. But when your email address ends up being Butters Brazilian, it sounds to me like either a fantastic steakhouse that promises all of the Brazilian food plus butter, or a book series of a different nature, or all the hair is just gone off your body. Let me know. Or maybe it's you just smell delightful with like some bum cream. I don't know. It's not giving law firm. It's just not giving law firm. Like 5 of you have said, no, it's a South Park episode. Oh, man. Okay. Look, I'm sure it's somebody's last name. But okay. Look, I'm not mature. I've never claimed to be. I'm old, but I've never claimed to be mature. I will never grow up. And every time I had a case with the U.S. Postal Inspectors, their email address was at USPIS. And every single time I would sit there and just be like, piss. And I can't help it. It still makes me giggle. USPIS. It's just not okay. But it is. But the Butters Brazilian, I'm sure that the attorneys are lovely. I am sure it is all the last names. But it's just also like Mr. Butters. I don't know. I can't help it. I can't help it. Mr. Butters. Nina says, I am an analyst for USPIS. Look, man, so much shit went down with the Postal Service. Like, people think that it's just gonna be fine when they put it in the mail. No, it's not going to just be fine when you put it in the mail. And because there was a massive hub where I worked, our courthouse handled tons of USPIS cases. They're gonna find you, people. Until you figure out how to teleport, they're gonna find you. They have a whole team of investigators. It's like Target and Walmart. They might not pop you walking out of the store, but they're gonna find you. Their cameras can see how many nose hairs you have. They will count the pores on your face and every strand of hair on your head. They will tell you if you have dandruff. They might even recommend a shampoo. They're going to find you. They're going to find you. Peggy said, I worked a porn case with USPIS. They were great to work with. They were. USPIS was incredibly diligent. They were great to work with. Mr. Butters is such a great pet name. It is. Very distinguished. Mr. Butters. Okay, we'll be back to reality in a second. So, look, Attorney Lally's lawyer is not entirely wrong on the approach to this. The court needs to know, and that's what the court said today. The court said, I want to go in order. I need to know what the evidence is that we are talking about so I can wrap my head around it. It's like when your kid comes home and starts in the middle of a story involving a whole bunch of people that you don't know. And you're sitting there going, are we talking about Minecraft? Like, what's happening? That's kind of where the court is. The court's like, I need what? Discovery wasn't turned over. 10. Got it. We need to address the next bit. What that wasn't turned over is prejudicial that can't be remedied by the things we've already done. That's the chunk that the court wants to fill in the gaps. Once the court can wrap their brain around, these are the items of evidence, this is why it's prejudicial, then you can put Attorney Lally on the stand and be like, where the fuck was this stuff and why wasn't it turned over and what did you do to get it turned over? I understand the court being like, back up. So that makes sense to me because it's such a mess. And the court's trying to rein in the mess. I understand it. It's frustrating. And I can do both. I am frustrated. I get it. I am frustrated. And I can imagine the defense attorney is like, I have been hollering about not having discovery for years. And I imagine the victim's family is also absolutely fatigued and exhausted. The process of where we're at now is the outcropping of, it seems to me, no courts holding anyone responsible for turning over discovery in a timely fashion. I can't understand how the judges are just so chill. Why are we not pissed? But it also seems to me that this is becoming more and more of the norm. But I wonder, this is just, I wonder if the courts are going to become more aware that this is not, they have to know, but this is not a one case. I also wonder, and this is purely my speculation, I hope that a defense attorney in Massachusetts speaks to this. It's probably a conversation I should just have with David Yannetti. I wonder if, because these judges switch circuit, and I wonder if the judges rotating also frustrates the problem. Because if it is one judge handling this one case for 4 years, the judge is going to sit there and be like, you told me this 10 months ago. You told me this a year ago. You told me this 2 years ago. But if the judges are switching from criminal to civil and back again, they're not being told that. And so they have to start all over again with a judge being like, okay, you don't have discovery. Okay, what's the next date for discovery? I just wonder if all of the moving pieces keep allowing this to go on. Because a lot of the criminal, I mean, I haven't worked in a jurisdiction where judges rotate. I wonder how frustrating that is to the civil attorneys to get criminal judges who are like, why are you talking to me about depositions? Okay, what rules are we in? Because they're different. But I worked in a massive state with a massive county. And so the criminal judges were criminal judges. And when you told the criminal judge, hey, I'm going to get this to you, and then you show back up on the next court date because the court's put it out 8 weeks for you to handle it. If you show up and look at the court and are like, yeah, so we're not there yet. The court is going to look at you and be like, why? Why are we not there yet? Explain it to me. And well, because I have 150 cases is not a reasonable explanation. You have to get it done. So I wonder how this has gone on for this long. And I am sure the defense attorneys are incredibly frustrated. And everybody else just seems to be meh. Wild. But until they start holding it against the DAs in the way that their evidence doesn't get used at trial, and that's a hard remedy too. Like I'm not saying I don't get it. I get it. It's a really hard remedy to look at a case, especially a homicide case, to look at a case and be like, this is strong evidence. But you did not do your job. And if that means people who might be guilty go free, then that's the result. And it's hard as a judge because it can put the community at risk. But that's not the judge's job. That's the district attorney's job. And then that comes up in elections. But I understand for the judge to sit there and go, I don't like this. This result's a problem. It's going to be hard. But the hard decisions are how change gets made. And it's frustrating. And it's incredibly frustrating to victims. Because I imagine they feel like they have absolutely zero power in any of this and zero say in any of this. So the trial's getting continued again and again and again. And now we're talking about evidence that might not come in because of rules and people who didn't do their job. Yeah. Frustrating. Jess G said, what happens if the defendants stop waiving their right to speedy trial? It's a difficult thing, and I have never had to make this decision as a defense attorney. It's a great question. A, it can screech everything to a halt. B, judges can find good cause to continue. C, there could be concern that the discovery you don't have means you haven't been able to do your job as the defense attorney. Because if you don't have like search warrants or what we're talking about in this case, if you don't have search warrants, you can't run motions to suppress and keep evidence out if you never got the search warrants before trial. And so unless the courts are going to go the next step to say, okay, if the search warrants weren't turned over, everything that was gotten because of those search warrants stays out, it won't work. It'll end up just making it harder for defense attorneys to defend their clients because there won't be any repercussions. So, continuing on. Marina said, Emily, you said judges should stop letting late evidence in, but what happens when it's exculpatory to the defense? Like the Sallyport video. And I know the court didn't find that was irremediable, but what happens? Well, then the defense gets put in a position where they have to ask for more time because they have to get the evidence, or you do the whole trial. If someone gets convicted, it goes up on appeal. The appellate court looks at it and says, oh, this didn't get turned over. And the result is a new trial. And then you do it again. And there's a new trial. That is the result. So, Averill said some kind of fruit of the undisclosed tree. Well, it seems to me, and I, again, would need to do more case law research, that if the search warrant you got discovery from wasn't turned over and the defense can't run motions to exclude, it would seem to me that the logical conclusion is you would have to exclude everything unless the basis for those evidence items being turned over was disclosed. The court's not going to do that. It's just not likely to happen. So I know that there are times that I'm saying if the court would just, but it's frustrating. Deb V said, I love your cover, DDB. You're so unbiased and clear. I explain my biases when I have them. I am frustrated in this case, but also I was a trial attorney for a long time. So I can take my own frustration and put it to the side and tell you where I'm frustrated and tell you how the law is operating, even when I'm frustrated with how it's operating. And I do my best to explore that. On cases I can't cover, I just don't. Because there are cases I don't have objectivity on. And then I'm not really helpful because I'm just like, fuck this shit. Maybe sometimes that's helpful too. But when I don't have a lot of objectivity, I just tell you. Because there are cases where I don't have objectivity and I don't cover them. In this, I'm very frustrated, but I feel like I can be objective because I am pretty far outside of the situation. It doesn't mean it's not fuckery. This is really frustrating, but I'm also seeing how it's happening, and that's so frustrating. And I hope that covering it highlights A, that this shouldn't just be normal and okay, and B, where the defense attorneys are hitting walls of frustration, and then where the prosecution just seems to be like, meh. And where the case law supports all of this happening. So let's look real quick at the motion, the Commonwealth and defendant's request for a continuance. This is not the motion to dismiss. I have not found the motion to dismiss yet. When I do, I'm going to look at it and we'll do a summary of it because I want to get to some other stuff today too. So we're going to swoop a doop. Susan, that's why I don't. Susan said it's hard to cover cases that are harm to children. I don't have objectivity in those. And I still have to send my kids to school every day. So I don't. And if I do, like the Ruby Frankie case, I will cover the legal aspects and then not the other parts. Let's see. We're going to swoop real quick and cover briefly this document and then move on to talking a bit about, well, Proctor wanting his job back. So this is, let's pull that up. This is the Commonwealth and defendant's request for continuance and reduction of the defendant's bail. This motion itself is wild. This alone is incredibly unique. This is why the defendant that had been set no bail in a murder case got bail, because of how much was going on. Let's see. And yes, today I am not answering questions in just Q&A. We're just interspersing them. I hope that that's the most helpful because of how much is going on in this case. Do you think Lally lost significant credibility after the Reed trial? Not necessarily, because he didn't seem rattled at all when he was testifying about the process for discovery. And Proctor's out here being like, I don't understand what the big deal is. Why'd y'all fire me? No one seems to think this is a problem. Which means this is way too normal. Everyone's real comfortable. Commonwealth and defendant's request for a continuance and reduction of the defendant's bail. Now comes the parties together, who respectfully request that the court continue the September 9th, 2025 trial date. As grounds, therefore, the parties respond. On February 20th, 2025, the Commonwealth filed its notice of discovery, Roman numerals, a lot of them, which contained items number 3 through 184. What the fuck? Let me back this up real quick. A, I'm digging the typewriter vibes. B, the indictment on this case, and I'm pulling up the press release because it's the fastest one for me to pull up. The grand jury indicted Myles King in December of 2021. The shooting occurred July 10th, 2021. This says that they turned over bait stamps 23 through 471 on February 20th, 2025. Did the defense have like 3 police reports? Destiny, I feel this in my soul. Destiny said, I own a typewriter. I love it. It itches my brain. Typing was one of my favorite classes in high school. I have in the pause, in the background back there, I'll have to grab it. I have a typewriter styled Bluetooth keyboard. And I love it, except when my nails are too long. And then I can't type on it properly. I had to go a little shorter. Emily, how does the ADHD work? I got frustrated with my camera, so I needed an entire new camera system. I know. Is this a ridiculous choice to make? Yep. It was. But I needed a new camera because it's just what I needed. And I could not move on until a new camera was had. So new camera was had, especially as we got into DCI season because things move fast. And so I needed to go a little shorter with my nails because of my camera. Because I could not hold it properly because my nails had gotten too long. Emily, this is ridiculous. I know. Everything is kind of a snowball. It's like, well, I got frustrated and then I needed to change everything. Emily, you're disassociating from your discomfort. I'm so uncomfortable. Klaus 4040 said my parents still have 2 typewriters from the 1920s. That's so fucking good. I love it. Keep them always. I am so like my scalp is itching. I am so uncomfortable with this statement. February 20th, 2025, the Commonwealth filed its notice of discovery, which contained items number 3 through 184, bait stamp 23 through 471. I hope that the non-bait stamps things came before, because this is well into discovery notice 28. Did they just start bait stamping with discovery 28 or 29? Emily, you should expect to be frustrated. On April 16th, 2025, the Commonwealth provided notice of discovery 29, which contained January 28th, 2025 Norfolk grand jury minutes relative to the return of jail calls of Myles King that were obtained under a grand jury subpoena in 2021. Okay. On May 15th, 2025, the Commonwealth provided notice of discovery 31, which contained items number 242 through 336, bait stamp 1893. There's our normal volume of murder trial discovery. Bait stamp 1893 through 2026. Those are page numbers. On May 28th, 2025, the defendant filed defendant's motion to dismiss or, in the alternative, release King on bail and continue the trial date given the voluminous late disclosed evidence. The court's already done part of that. The court has released defendant King on bail and continued the trial date. Those things have happened. So the motion to dismiss is still pending. The other part of the request has happened. A hearing on the motion to dismiss has not been scheduled. This was filed June 24th, 2025. So this is before that first hearing in July. So the hearings have now started on that motion to dismiss. In the motion, the defense articulated its reasons for why he would be prejudiced if a continuance was not allowed in the matter. Yeah, the defense is like, I just got a fuck ton of new information. I have to do my entire job now. Because now you just gave it to me. So the defense said there's no way they can move forward with the trial date. In the alternative, the defense has moved that evidence be excluded at trial for any evidence provided in those late discovery notices. Yeah, that's a reasonable request. Counsel for King is in the process of reviewing 6 search warrants and affidavits not previously provided involving the following: request for pinging, Stingray. I'm not sure what they mean by that. The cell site simulator, the range to tower activity, cell phone tower locations for phones. So 6 search warrants regarding phones and tech. Additionally, a sample of the late discovery includes, and they are going to list them. There's a lot of cell phone evidence in this case, it seems. For those of you just coming in, it is a motion joint between the Commonwealth and the defense. Everybody's on this motion. A sample of the late discovery includes police reports from July 2021, MSP crime lab reports, BRIC reports of other suspects, at least one witness who died before his name was ever turned over to King. The details of that are going to matter. The details of that witness are going to matter in the motion to dismiss. And I imagine that's where the defense is going to start. ATF trace summaries, license plate reader information, preservation requests, and information from Facebook, Snapchat, Twitter, YouTube. Because, yeah, after the shooting, they should have sent out preservation requests. Photo arrays, those are for identifying suspects. Tower dump records and analysis of tower dump records. That's literally taking everything off a cell phone tower and seeing what pinged. Phone information charts, police reports from Milton Police from July of 2021. And we heard at the last hearing that Milton Police would be testifying. I imagine what the defense expects Milton Police to say is, we gave all those things to Trooper Proctor because this is a Proctor case. This is an entire fucking case file. All of you are like, that seems like a lot. Yeah. This is the entire case file. Police reports from Milton Police from July of 2021. Police reports from Quincy Police, July of 2021. T-Mobile, CALEA, Kalia. I can't pronounce that acronym. T-Mobile lawful intercept worksheets from different dates in July and August 2021. The Bode, which is the laboratory we saw in the Reed case, the Bode DNA case report, 911 radio transmissions, August 2019 social media post by defendant. I mean, at least that they have, or should. Grand jury minutes from April 16th, 2025, 4 years after indictment for King's jail calls. Why do you need a grand jury for jail calls? Can't you just get them? You can just request. What? CopLink reports. On April 14th, 2025, the Norfolk County District Attorney's Office handed counsel for defendants an envelope containing additional discovery materials in this case. These items are listed below. So what was turned over in April 2025? Commonwealth Notice of Discovery 28? Facebook.com preservation request from January 14th, 2021. See, these at least have bait stamps numbers. That's helpful. Facebook.com Instagram preservation. Wouldn't that be meta? What? No, Emily, just keep reading. Instagram preservation request response from July 14th, 2021. Milton Police Department preservation request to Snapchat. Just as a note, Snapchat doesn't disappear. Everybody's like, oh, it just disappeared. Snapchat doesn't disappear. Snapchat preservation request response. Snapchat preservation request response. Different bait stamp number. Twitter preservation responses. YouTube preservation request and responses. Facebook response. Milton Police Department chain of custody. Oh, at least there's a chain of custody. I mean, they didn't get it for 4 fucking years, but at least there's a chain of custody. Facebook response to law enforcement online request. Facebook preservation request. On and on and on. Footnote 1. None of this late discovery involves the motion for discovery regarding Proctor and his team. Interesting. So footnote 1, all of the discovery that was turned over April 14th is from other sources. And then these are additional preservation requests, requests from ATF, requests from Milton Police Department. And I'm just scrolling on and on and on and on and on. These are all things gotten from elsewhere. I'm just going to scroll to the end of this until we get to the last number. Let's see. We're on 115, 130. 137. This is a lot of cell phone stuff. Search warrant packets. More search warrant packets. Tower analysis. So if you're like, why does the judge want them to get together on what all of this stuff is? This is why. But it should be based off of these Bates numbers, but not everything's Bates numbers, right? And that's a problem too. A lot of this is from Milton Police Department. Videos. Let's see. Traffic cams. These are all things they would have had early on in the case. It's not like these are new things. These are things that truly were not turned over. Because you would have had all of this. Milton Police Department crime scene. It says pies. I think it means pictures. Where did we end? We ended at 184 separate items covering hundreds of pages of discovery. And a lot of this is from 2021. So, let's see. When we got to, because a lot of you are asking about the witness, there is a note in this motion. I will look into it more and see if it's in other motions because I stick to what's filed in court. But they indicate that a witness passed away before the discovery. The defense wrote that in their motion. This is a joint motion with the prosecution. I don't have more information on that. But I imagine it's going to be one of the first things the defense argues about because that is one of the type of things where, well, Your Honor, we're never going to be able to interview this witness because we cannot, because we didn't even know this witness existed. So that's their item number 4. So one witness who died before his name was turned over to King. So the defense didn't get to interview him. Now, if that's a witness that's an eyewitness, it's different than if it's a witness who, you know, is somebody who would authenticate a video that can be done another way. It really, really just depends. I don't have enough information to go into it more deeply. I'll look for that, but I don't have it today. as we are pulling through this. But I will be pulling more court documents just so we have more context when this comes back into court, because the defense is going to argue that that's prejudicial. But I need more before I can give you my thoughts on that. And we'll see this play out in court more. Hold on, we got to get back to the end. It is just so much discovery that was not turned over until April of 2025. It's insane. It just doesn't make any sense, because most of this is from 2021. Like even the 2022 and 2023 things just get turned over when they're done. So, Way of King said, why ask for a continuance? Shouldn't all of this be excluded? The court's not going to exclude it. And the difficult position for the defense is some of this might help their case. And if it helps their case, they can't just exclude it. It's a lot of stuff. And then some of this isn't even noted with individual numbers like it was above. This is stuff that was turned over June 12th. I don't know why they stopped numbering it. We got to 337 and then they just stopped. I don't know why. Someone got tired? I'm just being facetious at this point. But June 12th, more discovery was turned over, and they're listing all the discovery that wasn't even turned over till June. So, and then the numbering stops, but we're over 300 different individually named items and hundreds of pages. So, DNA testing, and then some of these are motions, which don't necessarily count. I'm not sure what the retired 247 items of the criminalistics unit is, but they have listed out, when we say voluminous information. And a lot of this is lab information at this point. These look like CVs. Oh, it was all contained within that one number. Fair enough. 338 is the CV, one USB of all of these different lab personnel. 3 of the CVs and proficiency testing provided are for the analysts as identified on the analyst forms that can be found. It's so much stuff. 339, Mass State Police nonconformity log, proficiency testing, and then listing everybody's proficiency testing. So it's one item, but it's dozens of pages. The Commonwealth has requested discovery packet from Bode for the testing performed in this matter. It is anticipated this will be provided on or before July 1st, 2025. How is it just not done? The newly disclosed discovery contains exculpatory information that will require defense counsel to track down and interview witnesses, but also will require investigation to undermine some of the new information the Commonwealth will seek to introduce against King. Defense counsel must review, discuss, investigate this new evidence, incorporate into the defense strategy. Because of the late discovery, instead of preparing for trial with the discovery that was previously disclosed in the case, counsel must now process all of the newly discovered or new discovery and reformulate the defense. Counsel for the defendant articulated in the motion that she was reviewing 6 search warrants and affidavits that had not been previously disclosed to the defense. Counsel for the defendant indicates an intention to file a motion to suppress the evidence obtained as a result of the warrants, which you can't do until you have the warrants. One of the motions the defense has indicated it will move to suppress is the CSLI evidence that was obtained with a search warrant in 2021. That evidence was submitted to the grand jury in 2021. The Commonwealth intends to introduce this evidence at trial. It's a critical piece of evidence to the Commonwealth's case. On June 17th, the court issued a ruling in this matter, and in Commonwealth versus, the court said all these names. These are the 4 other cases, not including Walsh, that the court listed today. On June 17th, the court issued a ruling in this matter and the others, requiring the Commonwealth to make further productions regarding former Trooper Proctor's work phone and personal phone. So that's the court's order from June 17th that they were addressing at the beginning of the day. The Commonwealth expects that this further examination, wait, nope, I missed a sentence. Sorry, former Trooper Proctor's work phone and personal phone. The Commonwealth expects that this further examination will also be time consuming and may require further protective orders to comply with the court's order. So the Commonwealth hasn't seen it yet. And the Commonwealth is like, I need to see it before we can turn it over, and we might even need more time. You see the issue that becomes difficult to untangle at this point, right? It is an issue difficult to untangle. Excuse me, and frustrating. Like, how frustrating is this? All. The answer is all. All frustrating. On June 17th, the court issued a ruling in this matter. The prosecution needs more time to go through former Pooper Proctor. Yep, that's where we're at. Former Trooper Proctor's personal phone, which is currently not in the custody of the Commonwealth. They don't have it. They might need protective orders. On June 2nd, 2025, the court determined that bail was appropriate in this matter, and the court noted that the defendant is indigent and that he has been detained for the past 4 years. That's a finding that will go to ability to pay. The court noted in its findings an order that the reason for setting a cash bail in this matter was the, quote, Commonwealth has recently provided discovery that included hundreds of pages of additional discovery, including 6 search warrants. And the defense said today there were still some things they did not have. Including hundreds of pages of additional discovery, 6 search warrants, forensic reports, investigators' notes, police reports, and other documents that have not been previously disclosed despite the age of the case. As a reason for bail, the court cited the defendant's strong family support and minimal record. Counsel for the defendant, who noted that the defendant has been held since he was 21 years old, has represented to this court in the Commonwealth that the defendant is unable to post more than $2,500 in bond. The release conditions proposed by the court and accepted by the parties would require the wearing of a GPS device, 24-hour home confinement, and that the defendant could only leave his home for attorney and legal, medical, or probation appointments. Since the parties are 2 months from the September trial date, the parties will not be able to litigate the necessary motions to suppress and dismiss, nor will the defendant be able to properly investigate any new defenses. Without continuance, the parties will not be able to litigate the necessary motions and prepare for a first-degree murder trial. It is due to these late arising issues, including Judge Doolin's June 17th memorandum of decision and order regarding Trooper Proctor's work and personal cell, that the parties are not able to try this matter in September. The Commonwealth conditions its agreement for a reduction in King's bail on King's assent to a continuance of the September trial date after the Commonwealth consulted with the victim's family. A continuance in this matter is in the best interest of all parties in light of the continuance, the currently posted bail or currently imposed bail. Oh, I thought it was no bail. It wasn't. It was $100,000. It was like no bail because of inability to pay. Currently imposed bail of $100,000 would result in the defendant being detained until the matter can be tried. And then we know that the bail was set lower and that the defendant was, in fact, released on bail in June. So, one of the outstanding issues in this case is the feds turning over former Trooper Proctor's work and personal cell. Any additional protective orders that are needed to turn that over. Some of you are like, Trooper Proctor probably yeeted that. This is what the feds already have. So it is not new stuff they are seeking. But they're not the only ones seeking more discovery. Trooper Proctor is also seeking discovery. We need to talk about former Trooper Proctor real quick. So lots of swoops today. Lots of topics. One case, one overarching umbrella, many topics. Let's talk about Proctor because he was in court yesterday too. In court. Trooper Proctor had an administrative hearing yesterday. For those of you that are like, can we see those? No, administrative hearings are generally closed to the public. The fact that it was open to the public is actually pretty surprising and helpful that it's open to the public. But Trooper Proctor is going through the administrative appeal to get his job back. So we're going to take a look real quick at some of the articles, or one of the articles that came up in that hearing where they did what they do and set new dates. So this reporting is coming to us from Boston 10, and then I'm going to have to put reader mode on immediately because there are so many autoplay videos that it hurts my brain. But for those of you being like, wait, Trooper Proctor's waiting for discovery. Yes, we have to just go to reader mode. Reader mode is so much easier on my brain. For those of you that this reader mode makes your brain itchy, I apologize. It makes it so much easier for me to read. Witness to testify in ex-Trooper Michael Proctor's firing appeal later this month. Former Massachusetts State Police Trooper Michael Proctor, the lead investigator during the Karen Reed case, had a hearing scheduled before the Civil Service Commission on Monday as he appeals his termination. And we're learning more about how the process will move forward. Proctor was fired in March after an initial investigation. I mean, he was terminated without pay right after the trial. Then he had to do all the civil service stuff. There were like 4 different trial days, and then they recommended termination. Then he was terminated. And now he's appealing that termination, saying, but Your Honor, or appeal board, it's not fair. It's not fair. Nobody else is getting fired. Why do I have to get fired? So Monday's status hearing was mostly a discussion of dates and deadline discoveries. A full hearing is scheduled for August 26th, a delay from the original date set of August 19th. Shocking. During that hearing, State Police plan to call its sole witness for direct examination, Lieutenant Kevin Dwyer. Proctor's attorney will cross-examine Dwyer the following day. After that, the entire case will be continued till October. So 1 day of evidence and then continue. Because Proctor's still waiting for discovery. So he's like, can we just continue it? Can we just continue it? And apparently that's what's happening. Proctor's attorneys have requested more than 200 disciplinary files for a disparate treatment argument. They're saying he didn't get treated fairly. Other people weren't terminated for the same thing. So, state police, if you have been disciplined, Proctor wants to bring your discipline in to show that he is not being treated fairly. So if you don't think his lawyers are going to grab at everyone, yeah, they're going to grab at everything. It's a reason lifeguards put themselves with a little personal distance between somebody who's going down, because people who are going down grab everything around them and can bring them down with it. It's why they use like lifeguard cans and rings and the noodly things. You need a little distance. There's no distance here. They're going grab it, grab it, grab it, grab it. 200 disciplinary files to show that he is being treated unfairly and others were not fired for similar behavior. That is the argument. The article goes on to say basically they will try to show that he was punished more harshly than previous troopers for similar, transgressions. State police are still working on producing those records. You're right, everybody. State police is still trying to get that discovery to Proctor. It's so loud in my ears. I'm so sorry. I'm so sorry. Everyone should be fired then. Is that the argument? Fire everybody. So everybody's laundry's getting aired. David said, oh, we have an actual tiny violin now. Yes, a Leonard sent it to me. Thank you. I have a mini trombone somewhere too. I think Griffin might have it. I'll have to look for it. It can't all be pickle up in here. But yes, we have an actual tiny violin. Actual tiny violin. I did not find it Destined to be. I will find one on Amazon and link it. I will find it and link it. We'll find one. And I'll put it in the description after stream. For sure. Why not? Emily, you're going to throw in some affiliate links for a tiny violin? I mean, if you guys are going to buy it because we're using it on stream, yes. Yes, we will. Because then we can do more shit. So Proctor's arguing that similar transgressions he was not fired for. Is Proctor going to accidentally unearth the rest of the nest? However, I don't know if what Proctor's arguing is true, because Proctor sees this as text messages. So I don't know if I really resonate with Proctor's judgment on this one, but again, lawyers are going to lawyer. In Proctor's situation, he is presumably looking for evidence that other people engaged in similar or even worse misconduct, but were treated more favorably than he was, said Allie Willard, an employment law attorney. For instance, two people in slightly different roles but committed a very similar infraction, and say one was female and was not disciplined and one was male and was terminated, that would support or at least provide some evidence from which a finder of fact could infer discrimination. So they were going to say that others were not disciplined as harshly as he was treated unfairly. Well, it's going to be real interesting if everything comes forward. And then what happens if he does get his job back? And I'm not saying that he should. I don't have enough information to say either way. But you drag everybody into this and then get your job back. Imagine going back to work. Imagine what that's like. So bring it all to light then. The State Civil Service Commission acts as the intermediary in cases involving state and local worker discipline, layoffs, alleged violations of state civil service law, and more. Proctor appeared virtually before the board in a hearing earlier this month and then yesterday. That meeting was procedural, reviewing how the appeal process would work and checking in on a disagreement over evidence the lawyers for Proctor and state police were seeking in the case. Yeah, they had a whole meeting about what evidence they might get. And then they had another meeting and they said, wait, but we didn't get the evidence yet. And then they're going to have another meeting and they're going to call one person to testify over 2 days, who I think was one of the decision makers in the board that found the violations. Then there's going to be a continuation till October to get the rest of the records. This isn't going to be done probably before the end of the year. And now Proctor has to wait without pay and without job. The lawyer said they had reached an agreement before the hearing involving a trip to a police facility together to pull records they were seeking. Oh, weird. You had to actually go to the department and go looking through files to find the records you wanted? So strange. During comments made in a Dateline interview about the Reed case, Proctor said he wanted his job back. He said nobody gets fired over text messages. I mean, I'm paraphrasing, but I covered his interview as well. State police have said they were confident in the decision to terminate Proctor, though leadership noted he had the right to go through the process of appealing his decision. It's a more gracious statement than the statement that Brennan made about the jury trial. It's really there is a system. He has the right to go through the system. State police have said they were confident in the decision, but he has the right to appeal. Karen Reed's murder trials are in the past, but some key players in the case are still dealing with the repercussions. Yup. The fallout, the ripple effect of this is not going to be done quickly. The Massachusetts Post Commission, which certifies state and local law enforcement officers, lists Proctor as an unassigned officer with his certification status considered restricted. This means that while his certification remains valid and he could work as an officer in the state in the future, he is not currently authorized to serve by a particular law enforcement agency. Is he going to end up working like nightclub security or something. After the launch of the Massachusetts State Police Excellence Initiative to build public trust while enhancing safety, we asked if the initiative came out of the Karen Read case. Maybe just let there be cameras in all of these hearings. If you want, we're just spitballing here. I mean, I haven't like focus grouped it. I'm not really good with corporate buzzwords. I don't speak corporate because I was a government employee for a very long time. And like, then all the corporate people like infiltrated. But so if you're doing the MSPEI to build public trust and enhance safety, maybe, just maybe, let people see the process work. Wild, I know. Transparency might go a long way. Maybe that's just me. But if you want to build trust, show the public what's happening. They go on to talk about the Read case a little bit and say that the Read case has caused other fallout at Mass State Police. Proctor Supervisor Buchanan was reassigned out of the Norfolk County District Attorney's Office. He wasn't the only one at all. So, Welcher's emotional support laptop, the screen name. Does Proctor saying he would do nothing different in the investigation help or hurt his case? It's not going to be relevant. Would he be better off admitting he should have done better and asking for mercy? Probably not. I don't think it will come up either way because the question on appeal isn't really Trooper Proctor. The question on appeal for the Civil Service Board is, was Proctor unfairly disciplined or disciplined differently than others would have been? So is he treated differently? Or for similar violations were people also terminated? That's the question on Proctor's termination. It's not really about his behavior in so much that they already found the violations and fired him for those violations. But if other people weren't fired for similar violations, then was he fired unfairly? That's the core of the question. All right. Shall we talk about, I really don't want to talk about Trooper Proctor anymore. I don't think there's much more to talk about. His civil service stuff is going to take a while. We might not see a ton of it. It just depends. I hope that the initiative leans towards transparency, but they might not. It might be hearings that need to be attended in person or remotely and then reported on. So we will see. But we have more information coming out in Karen Read's civil case. So we have a couple things to talk about in light of Karen Read's civil case, and then we'll get to questions. Yes? Yay. All right. This is, this is Sparta. No, it shouldn't be. This is from August 2nd from the Gazette Extra. That is where I found it. I'm going to put it in reader mode in a second. Karen Read's civil attorneys demand documents from the DA. FBI, the who?
The FBI!
The what?
The FBI!
MSP and DOJ. Oh, no reader mode. Rude. That was rude. All right, we'll do our best with the fact that we can't just do the things. I'll just try not to look at the things. We'll try to do it that way. Let's see. I'm trying to move me out of the way, which is not working entirely well. Nope. Can we, Emily, get it together. All right, let's try it this way. That's terrible. No, we're not doing that. Nobody can read that. So frustrating. All right, we're gonna make do with ads the best we can. Attorneys defending Karen Read in a civil suit by the family of John O'Keefe are demanding a wide range of documents involving her criminal case from state prosecutors and Mass State Police and federal agents. Subpoenas filed in the civil action demand all documents, communication, audio, or video recordings, or other data or items of any kind relating in any way to the investigation and prosecution of Karen Read and to the death of John O'Keefe, or any investigation into his death, as well as a wide array of related materials to be turned over to Read's attorney's office by Wednesday at 10 a.m. I'm sure that hasn't happened, but we'll see. The request targets the Norfolk District Attorney's Office, which prosecuted Read for the murder of O'Keefe, a Boston police officer she had dated for about 2 years before his death. Jurors earlier this year acquitted Read of criminal charges and convicted her of drunk driving. The end of the criminal trial meant that the civil action filed by the O'Keefe family could resume because it had been essentially stayed. The subpoenas go much further than the Norfolk DA's office. However, they also target any materials held by state police, from the FBI, the DOJ, and anyone else. So the defense are saying, look, we've got this civil suit. We need all of the information. Give us all of the information. So the demands also target individuals affiliated with those individuals, including case investigators Yuri Buchanan, former trooper or fire trooper Michael Proctor. That goes through Proctor getting fired. We know that. The MSP inquiry led to his firing, that he had shared negative personal opinions of Read from early. Well, they found bias, among other things, and even shared classified investigation information on the case with those not entitled to it. Just weeks ago, defense attorneys in several cases involving Proctor were told that the Norfolk DA had a cache of iCloud information from his work and personal phones and that it would be deleted. Well, there's a little bit more to that. We'll get there. Those attorneys who claimed they were blindsided by the disclosure this information existed then sought and won an emergency month-long extension of its scheduled deletion, arguing the trove could contain materials that could show a similar bias involving their clients. So in addition to the Fed information is mostly what was being talked about in court. This is in addition to the Fed information. It's wild. Read's civil attorneys likewise want their hands on this information. For the avoidance of doubt, this subpoena demands that you maintain and do not delete, discard, or otherwise destroy any portion of Michael Proctor's iCloud or other data that you may have in your current possession, custody, control, including but not limited to the data subject to a federal protective court order, which you previously agreed at a hearing before the Norfolk Superior Court to maintain until July 25th, 2025. The subpoena also requests all documents and communications with FBI, DOJ, or MSP in the cases of Sandra Birchmore, Brian Walsh, and Myles King, all of whom are related cases. Well, no, all of whom are related to case investigations by Norfolk. Those are all Proctor cases. Federal prosecutors say Birchmore was killed in her Canton apartment by the then Stoughton cop, Matthew Farwell. That case won't be streamed. I covered it briefly, but that case won't be streamed because it's federal. Walsh is accused of having murdered his wife at their Cohasset home on January 1st, 2023. King is accused of the shooting death of Marquise Simmons, 25, outside his mother's home in Milton before 6 p.m. on July 10th, 2021. The Proctor cases. So Read's civil attorneys are going after everything in connection to the ongoing civil case. So Read's attorneys are like, there are these other discovery issues going on in these cases, so we know what's over there. We want all of it in connection to the civil wrongful death case, which I imagine for Read's attorneys, they're pretty happy with. We want to see everything, even things we might not have seen then, because we're going to need it in the civil case. Because the civil case is going to be pointing at Karen Read with a much different standard. And now the defense is saying, give us everything, because that's what we need to defend the civil case. And speaking of the civil case, which we covered briefly at the beginning, the civil case is being joined by the criminal defense attorneys. And I'm going to pull up video of this, but the audio of this has, well, it's an Easter egg for some, but it is a musical reference that made me giggle just a little bit. So I'm going to pull up the, before I pull up the video on social, I'm going to pull up the audio from sports radio this morning at like 7 a.m. And then I will link below the entire episode from the Greg Hill show if you guys want to check that out. Let me make sure I give that to Megalina so she has it. It's this one. So we will link the show if you want to go find that later. But this is the very beginning of the show. You're going to hear audio only because it's a radio program. And then we'll go to the video. So, oh, I didn't swoop. This will be the swoop as we talk about Alan Jackson's attorney interview this morning. It's morning radio, folks. Name that tune. Emily, really? You're going to risk it? Yeah, we're going to risk it. Name that tune and who sings it, because that's really relevant.
It was a little over a month ago that Karen Reed was acquitted on a second-degree murder charge in a case that many in the nation.
All of you chat are just like, absolutely. They're leading into the interview with Alan Jackson, playing Alan Jackson. Alan Jackson, not that one. Yep. I love that they took a moment for a little fun with Attorney Jackson's name being Alan Jackson, other Alan Jackson. So all of you who are fans of Alan Jackson country music, little itty bitty, I thought it was delightful. I was like, that is fun. I mean, I'm not up early enough most days to listen to morning radio. That's just not happening. But that was delightful. We love a good little morning radio moment. This is video from this radio show this morning with Alan Jackson calling in, which if this is not the entire thing, I'll go grab just the audio from the radio show. But yeah, the full... I don't think this is the full thing because it's only about 45 seconds long. But just so we have a visual before we go to the rest of the audio.
You took to Instagram over the weekend to say that you're not done yet and the next chapter is coming. I know there are a lot of us who want to know what that means, Alan.
Well, I was just sort of generally referring to something I'm very excited about, which is I've agreed to join Karen and her very capable defense team in the civil action. So I'll be coming back to Boston. You haven't seen the last of me yet. The really good news is I'm going to be bringing Elizabeth Little with me as well. So
that is good news.
The band is not just staying together, getting back together, but we're intending on writing a few new chapters.
You took to Instagram.
So that is a quick clip. We're going to go to the rest of the audio interview on this because Attorney Jackson indicated that he is joining the civil defense team in Karen Reed's civil case. What does that mean? Well, it means that he is bringing probably a film crew with him at this point, honestly. But B, that he is bringing all the knowledge of everything that happened in the criminal case to catch the civil attorneys up on it too. And we've heard from everyone who's worked with Karen Reed that she is not only incredibly astute, but has like photographic memory for the things that went on in her case. So for the civil defense attorneys, they also have the trove of information from their client. But bringing in a trial attorney and a criminal attorney, the civil attorneys can do all the civil motion, but trial is trial, even though the standard is different. So if it goes to trial, I'm not surprised that they're bringing Alan Jackson and Attorney Little onto the team. They work at the same firm together. So let's go to the radio real quick and hear the rest of that interview, which means we're going to get some overlap of that part, which I think is fine. I think it's just fine. This will be linked below.
Certainly around here, we're obsessed with.
Also, the audio is just so much better from the from the radio, right?
Us this morning on this show for the first time, one of her attorneys, Alan Jackson. Alan, good morning.
Oh yeah, all the depositions, you guys.
Hey, Greg, how are you this morning?
Great to have you on. I know it's early out there in California. Appreciate you taking the time.
This is at the 7 a.m. Eastern hour. So yeah, it's like 4 whatever in the morning.
I mean, I've been trying to get you on since the trial, but I mean, I know you had other things you had to do.
He doesn't answer his emails.
Well, you know, I need a little courting. You didn't court me, Greg. Come on.
Well, I tried. You took to Instagram.
We're just going to email CAA and be like, look, can we just want to talk to Miss Little. Can we do that?
That you're not done yet. And next
yes, apparently he's on
chapter
Instagram.
is coming. I know there are a lot of us who want to know what that means, Alan.
Well, I was just sort of generally referring to something I'm very excited about, which is I've agreed to join Karen and her very capable defense team in the civil action. So I'll be coming back to Boston. You haven't seen the last of me yet. The really good news is I'm going to be bringing Elizabeth Little with me as well.
That makes me excited.
The band is not just staying together, getting back together, but we're intending on writing a few new chapters.
That legal team, you're the legal team that you have joined, has sent subpoenas to the Mass State Police and the Norfolk DA's office, seeking
Kimberly,
information on witnesses who testified at the trial.
Kimberly's like, this is on. There's video of this call. Well, video of the host talking. I can go grab it real quick. Hold on. I didn't, because the radio sounded so good, I didn't even think to grab it. And I truly, as we were getting things together, was doing stuff with Griffin. Hold on. But I'm happy to grab it. We all love a good visual. We want to see who's talking. Oh, this is the full video. Perfect.
In a case.
Thanks, chat. You guys are the best. We'll just do it that way. I'm still going to link the audio down below because the audio is so freaking good, but we'll grab the YouTube video. Streaming is dynamic, and that's why we have chat, because chat is what? Chat is what? Chat is bay. Chat is bay. But this is just the call-in, so no, it'll just be the radio host. Is not going to be Jackson. It's just, oh, hold on. Let me move my face out of the way just a little bit. Nope, that's too much. A little bit. We'll move our face out of the way just a little bit, because this is not court. It's so much different. Thank you, chat. Chat is like, chat is bay. Chat is bay. And it's like, no, we rather look at people talking, even if it's video of a radio show. We'd rather look at people talking, which is fair. Let me scoot past the first 30 seconds that we've already heard of Alan Jackson needing a little courting. We'll just look. There's a lot of knowledge to be gained here, but also I'm sure because they are, Karen Reed is writing a book, Jackson and her signed a movie deal. We're going to see a lot more of this in the years to come.
To join Karen and her very capable defense team in the civil action. So I'll be coming back to Boston. You haven't seen the last of me yet. The really good news is I'm going to be bringing Elizabeth Little with me as well. So the band is not just staying together, getting back together, but we're intending on writing a few new chapters.
That legal team,
into the civil
legal
case
team that you have joined, has sent subpoenas to the Mass State Police.
We just
and
talked
the
about
Norfolk
those.
DA's office, seeking information on witnesses who testified at the trial, on Michael Proctor, and on evidence from the federal investigation.
I mean, it's full
we
mention it
discussed
all
the
now.
federal investigation a lot on this show.
I mean, same.
From your perspective, in your opinion, did that federal investigation end?
That's my opinion!
No, I've never heard of such a thing. I know what Mr. Brennan said.
Emily, you're radio showing a radio show. Yes. I'm soundboarding a radio show. I am. And I do not apologize. It's interesting to me to hear Jackson say, do you think that the federal investigation is done? No. I've never heard of such a thing.
I know what the a hired gun said in court about being contacted and there being a closure to the case. We weren't contacted. I was never contacted. I've never heard a word of that directly from the horse's mouth, and I've been doing this for a long time, and I can tell you it's not a thing. It's just not a Greg, you just don't do that. As a prosecutor, especially a federal prosecutor, you don't look at the target, call the target, and say, oh, yeah, we're done here. What if something new comes up tomorrow or next week or next month and you're within the statute? You don't, quote unquote, close investigations. So that's something.
I don't disagree with Attorney Jackson. He made the statement, you don't call the target. Again, there's been much speculation. We don't know, but there's been much speculation that the target of the federal investigation was either the DA's office or the investigation itself, not looking into Karen Reed. But I still have to wonder if what the feds disclosed is that the grand jury's done. Because that would make sense to me. This is the only thing that makes sense to me, is that the feds say the grand jury is done. So you can hire ARCA because the grand jury's done. They're not coming back to the grand jury. And we can disclose some of this information because that grand jury is done. But that doesn't mean the investigation is done. It would make sense that the investigative grand jury is done, but nothing's ever really closed. So for Brennan to say the investigation's done, I think is probably broad and sweeping in a way that it runs counter to logic for me. So I could see it being somewhere in the middle. Not that the grand jury is done, but that not that the entire investigation is done, but that the grand jury is done. That's what makes sense to me. So, all right, let's continue on.
That I'd never heard of, and no, in my opinion,
it's an odd
thing.
There's
no such thing as a quote unquote closed investigation. They can say whatever they want over at the Norfolk DA's office. I'm sure that was a curated comment or a series of comments, but I'll leave it to the feds to do what the feds do best, and that is to investigate. And
they do keep shit secret.
Is continuing to happen, but that's just my opinion.
Speaking of the DA's office, should the taxpayers in this state be concerned with how much was spent on both of these trials?
Yes.
Oh God, yes. Yeah. This is that. I mean,
Emily, this isn't your interview.
Serves at the pleasure of the public. He's an elected official, and he's got responsibility to the public for their confidence and to their pocketbooks. I have no idea how much they spent. I know how much we spent, and I can imagine they spent as much or more. I mean, there were millions.
I mean, we know how much they spent on Brennan and Aperture alone. We're going to be in the millions of dollars. Millions of dollars.
Millions and millions and millions of dollars of taxpayer money spent that was completely unnecessary because of a persecution, not a prosecution, because of some sort of a personal vendetta. After the first trial, everybody knew what had happened inside that jury room, inside that deliberation room. She was acquitted. I've talked about this, the fact that Karen and I and our team may be the only attorney-client relationship where we've actually acquitted someone of murder twice in the same case.
I see why he says it,
they knew
but
that they couldn't prove this.
I see why he says it. Legally, it is a technical, not actually, but I get it, because we've seen jurors saying, no, we thought she wasn't guilty of all of this, but when we got down and got stuck on just the one, if you hang on just the lesser, everything goes back to trial again. Like, I get it.
Case coming out of the first trial, they knew they couldn't prove the case going into the first trial, that they pressed forward. And then, of course, following the debacle of the first trial and the joke that was the unrecorded verdict.
Well, he doesn't.
They forged ahead again, and it was some sort of, it turned from a professional, objective prosecution of a case to a personal vendetta. And it cost the taxpayers millions and millions and millions of dollars.
It cost the taxpayers way more than they should have paid.
Their special prosecutor alone.
So much.
His bill was north of $500,000, closing in on $600,000, just him,
right,
for a completely failed prosecution.
Which is odd. You worked in the DA's office in Los Angeles.
He ran for
as
DA
an
in Los
ADA.
Angeles.
You have perfectly capable ADAs who could have tried this case, and it wouldn't cost you $600,000, correct? That's normally the way it goes.
Of course.
Right?
Yeah, that's normally the way it goes. And if
Ask him the next question. Ask him. Oh, I don't know why that in Smolland. Ask him why. Ask him why. Ask him why. Ask Jackson why he thinks they brought in a special prosecutor. I want to know. For all of you who've already heard this interview, you're like, I hear you. Ask him why. I haven't heard this interview. I just grabbed the audio from it and was like, we'll talk about this later. So, yes, for everybody going, tell me why. I want to know. I want to know.
Michael Morrissey didn't have those kinds of prosecutors who could try the case capably, then maybe he needs to find another job. That's his only job, is to populate the courtrooms with people who are competent, not just competent, but ethical. I don't know, maybe
100%.
There were some ethical prosecutors inside that office who said, not just, I can't. They probably could have prosecuted the case. It's just a matter of calling witnesses and doing an opening and closing statement, putting on some evidence. I think he had prosecutors who said they wouldn't.
That was my speculation.
They didn't believe in it. So what does he do? He goes outside the parameters of the contours of his office and finds some defense attorney to come on board and switch.
And find some defense attorney, says the defense attorney. That's what I speculated too. Like that prosecutors were just like, nope, find someone else. Couldn't be me. That's the only thing that makes sense. However, if every attorney in your office says, I'm not doing that, don't. That's when you don't.
Hats midstream and become a prosecutor. It's outrageous. You just don't see this kind of thing.
Truly. Sorry.
Alan, I was so impressed with how you and your team were able to handle the first trial and the second trial, but it did feel so drastically different, the way in which you decided to handle witnesses.
Totally
and the first trial seemed like there was just bombshell after bombshell. It was much more McAlbert's heavy, while the second trial was much more database. What went into the decision to kind of switch things up and choose to go down that road at the second time around?
There wasn't a marked difference in what our theme and theory of the case was. As a matter of fact, there was no difference in what our theme and theory of the case was, which is the SUV never hit John. He wasn't killed by being hit by a car. That's the basic postulate. In the second trial, it was very clear that the prosecution was going to do something different. They were going to be, they were going to try to style themselves as a data-driven prosecution. We knew that the data helped us. So any trial lawyer has to do this. You have to be committed to your cause, but you also have to be able to be up on the balls of your feet. You have to be able to be nimble and pivot with the prosecution. Because you're not just...
Oh my God, we all just think alike. It's prosecutor brain. We all just think alike. Pivot! I didn't think we would get to a pivot today. I'm delighted. I am just delighted.
Do it.
This is why I don't listen to things before we cover them. Sometimes that goes badly. Most of the time that's delightful. I'm so glad I waited.
Parrying, you're defending, but you're also, to a certain degree, you're on the offense as well. So
yes, it's very much like
jousting. What we decided to do was shift and learn from the first trial that I wanted to press much, much, much harder on reasonable doubt and undermining everything they say about the data, because the data actually served our purposes. The data proved that the car did not hit. It did not collide with John O'Keefe. Right. And so that's what you saw in the second trial, is a much more sort of tactical approach. They didn't call certain witnesses. They didn't call Brian Higgins. They didn't call Brian Albert. There were big witnesses that they just forwent altogether. We knew that there was a chance they would do that. We didn't know until they closed their case who they were and weren't going to call. They didn't have to tell us in advance what their trial strategy was, but we were ready and able to sort of pivot on the move to not just defend against what they were presenting data-wise, but to attack them for not calling people like, oh, I don't know, how about Michael Proctor, the lead investigator on whose shoulders you base the entire prosecution, and you don't call him. So we knew that there was going to be some shifts, and part of being a good trial lawyer is to be able to make those shifts sort of on the fly, and that's what we did. And we did it with Karen's approval and with the rest of the team's approval.
Speaking of Michael Proctor, he has had a civil service hearing yesterday trying to get his job back, saying the suggestion is that he was not treated like other troopers.
I mean,
does he deserve to be a trooper in Massachusetts?
Oh my God! No, please tell me they're not going to give him his job back. He's claiming he wasn't treated like other troopers. Well, then act like other troopers. Don't do what you did.
Is he tempted to be like
trooper's hat off?
Is he tempted to be like, don't be a dick then? Because it sounds like then don't be a dick was what was not said.
And to become a sort of a sideshow. This guy had so many biases going into the case. I mean, it was embarrassing. I don't need to go into, and I won't go into all the details of what he did. No
one seems to be embarrassed
to the investigation, but to Karen Reed personally, just dehumanizing her, maintaining relationships with the people that he should have been investigating, the very people he should have been investigating. No. Look, to be a sworn officer and to take on the mantle of the protection of the community, that is a privilege, Greg and Courtney. That's a privilege. That is not a right. And he squandered that privilege with bias and a lack of objectivity and lying through his teeth about his own relationships, about dehumanizing with conduct that was dehumanizing of the person he was supposed to objectively be investigating. No, he's lost all his right to carry a badge and a gun. He's an embarrassment. He should never, ever, ever be in a position to control the community members that he serves. And that's exactly what being a police officer allows you to do. It's a lot of power, and he's not someone who should ever be commissioned with that power ever again.
Alan, you discussed objectivity. On a scale of 1 to 10,
I was like, where's the other voice coming from?
Judge Bev.
The producers. The producers.
Oh my God! That's a whopper,
sir. If you're going to be trying to pro hoc into Massachusetts, there has to be some chill. Okay, he's opted for no chill, and we've got a voice coming in from the producers booth.
Discussed objectivity.
Oh boy!
On a scale of 1 to 10, how much do you miss Judge Bev?
Oh my God, that's a whopper. If I go the rest of my life and never have to walk into a room with Judge Bev, God bless her, it'll be too soon. And by the way, that's the other thing is
sidestep that one.
I don't have to say it.
He doesn't get it.
I was right there in the mix. I was in the fishbowl. I was wondering if others were clocking what I was seeing. You know, sometimes you're so far in it. It's like a fish that doesn't know it's wet.
That's true.
I wasn't sure if others were seeing what I was seeing inside that courtroom, but a judge's job is to absolutely be unbiased, to put
their job to be a
all
referee.
of the biases aside. Everybody comes into life, any situation with certain biases. The job of a judge is to put those biases aside.
Right.
And she showed very, very quickly and undeniably that she could not and would not do that. There were rampant biases in favor of the prosecution, in favor of the Commonwealth, in favor of Mr. Lally and Ms. McLaughlin, in favor of Mr. Brennan once he took over.
You could definitely see which attorneys Judge Cannone liked better. Yeah, that was clear. Though they did get some rulings very much in their favor. They got yelled at amidst it. But they definitely got rulings in their favor. But you could definitely see who the judge liked better. When oftentimes the annoyance should have been reserved for either all of the attorneys or the prosecution. She didn't get nearly as annoyed with the prosecution as she did with the defense.
And against the defense from nearly day one, nearly from the moment I walked into court the first time on September 25th, 2022. So no, there was a breakdown of the entire system, and she was part of it.
We're
Do you
seeing
believe
it over and over again,
that there
apparently.
was a conspiracy to frame Karen Reed? Or we debated this a lot on this show with Curtis. Or do you think it was just, awful investigative work?
It's a combination of both, for sure, in my opinion. A combination of both. There was an awful investigative work, but it wasn't just incompetence. It went beyond just incompetence. You could read in Michael Proctor's text messages that it wasn't just incompetence. He had a view of her. He had a thought process about her from nearly day one, right? 16 hours into the investigation, he was already determining that he was going to make sure
100%
that it was going to get pinned on the girl. She's going to pay for this.
He didn't say that. He
said it out loud. He said the quiet part out loud. So it's not just incompetence. So now once you go beyond, outside the parameters of just incompetence and being stupid, which there was a lot of idiots.
That continues to be Jackson's characterization of it, which, again, when you're looking at the sum and substance of Proctor's texts are heavy charges for the girl, she's fucked. And when they hadn't even done barely an investigation yet, you didn't even have an autopsy report back. So yeah, it's real early to make those determinations.
It's involved in the investigation as well. Once you go beyond those parameters, now you start getting into the very troubling area of a cover-up. Well, we know that tragically, an officer has lost his life. And we also know that we're going to pin it on this girl. So what does that mean by definition, Greg? What does that mean by definition? It means that you're going to cover up what actually did happen. You're going to actively cover up who's responsible. And lo and behold, isn't it amazing that the person that's supposed to be investigating is connected to and related to, and with personal relationships, to the very people that should have been number one, number two, number three on the suspect list. So you tell me, was Karen Reed framed?
Alan, since the second trial, there have been videos, photos making their way.
He does a very good job of answering without answering, because there are still boundaries of what you can answer. He does a good job of answering without answering.
Around social media of inside 34 Fairview. It seems like the new owners let you guys inside, whether you were down in the basement looking at the flooring that was pulled up inside the garage.
Right.
There was a video of you outside yelling, and from the Albert's bedroom, you could hear yourself pretty clearly. Will there be any type of I know that you guys have signed on for different media rights. Will there be any type of way to dive deeper into that? Will that come up in anything?
Well, the pain point that the plaintiffs are going to have in their civil suit is this is a very different lawsuit. It's not a criminal lawsuit, and it's certainly not being governed by Judge Beverly Cannoni, who kept out so much of that information. That's why you're seeing it on social media rather than having seen it in the courtroom. All of it was relevant. We attempted to get most of it in. And we were denied, both in the first trial and the second trial. So this new lawsuit is probably a very good platform, I'd say, I would suggest to you, for a lot of that information to be aired out and aired out completely. I don't. That's not the last you're going to see of that.
He's like, again, he knows what he can't say and he knows what he can't say, but you can hear it. He is. Stay tuned, right? Stay tuned to the civil case. He's announcing that he's a part of the civil case on a day that Karen Reed was going to be in the news because of the Lally hearing. It is not an accident that he was giving this interview today, sharing all of this information, but it is we're going to see a lot more in the civil case because, again, the civil case standard is different. So Karen Reed is more in a position in the civil case to also prove that she's not responsible. So the civil case is going to air out quite a lot of this. And I don't think they're going to back away from that or shy away from that. So let's continue.
information.
Just
that and a lot of other information.
To be clear, when you said this new lawsuit is, so you're joining her civil defense team to defend against the wrongful death suit. Are you also,
Correct.
is Karen also planning a federal lawsuit on this case?
So that's a interesting question, not one that I'm willing to talk about right now. We have a
You're
lawsuit
under.
that's
Can
in
I
front of
remind
us.
you? Can I remind you? You're under oath.
Survey says.
We want to know. He's like, nah, I'm not going to answer that yet. I'm not going to answer that yet. Not yet. We're going to answer that later. Not going to talk about it just yet.
Do it.
But that sounds like that is definitely not an absolutely. That is not an affirmative. I wouldn't read into that as an affirmative. It means to me that they are going to strategize on whether or not the civil is going to be enough. That's where I'm at. Or they're going to wait and see what they can get because they've got time. They're going to wait and see how the civil unfolds. And that decision is not made yet.
Counselor, I object, and I move to strike that comment from the record immediately.
By the way, also, I offered countless legal strategies during the trial to Alan. Didn't use a single one of them. I just want to make that clear right now.
I think Alan needs your help.
I've seen carnival psychics with a better track record than Greg when it comes to legal prowess. I'm just suggesting maybe not.
Alan,
Greg, hey, we'll see what this new law.
Greg, you're going to get an extended answer, and if you poke the lawyer will poke back. It's like 4 a.m. in California. You're getting sassy, Attorney Jackson, and there will be no out-talking Attorney Jackson. He's just going to ban. Craig's like, wait, it's nope.
Entails. I can tell you this. I can say this. Karen has proved herself to be a fighter. She's not going to sit back in a corner and get punched, right? Everybody has a plan. I would suggest the following. Everybody has a plan, as the old saying goes, that Mike Tyson made famous,
to go for it
until they get hit in the mouth. And Karen Reed has shown that she knows how to hit others in the mouth, meaning how to fight back. I doubt seriously she's going to be a wallflower during the course of this new litation.
I don't doubt that.
Whatever that means, we'll see.
Okay,
Alan, I know you're probably got something else to do this morning than talk to us.
That's 100%. We're evaluating, and we're going to see what we need to do. We're going to see what we need to do. But yeah, I mean, Karen Reed has shown that she has the fortitude to withstand the ups and downs and rounds of litigation. So she is not going to shy away from litigation because it's litigation. Where some are like, I need to just move on. She's like, oh no, y'all drag me into this. We're not done. It's not going to be worse than that because at the end of the day, I'm not going to jail. So it's not going to be worse than that. So the rest of this is going to be easy. That surprises me none at all. All right, let's continue to hear what he has to say.
Just am so curious about the period between the trials. As someone who's, I don't understand, I've never studied law. Is there any prerequisite or is there any onus on the Norfolk County DA to prove either new information or how did you go from
just retry it.
The ending and the conclusion of the mistrial into the beginning of the next trial? What was that process like and what did the state have to do?
They can just do it again.
That's a great question. The state has an obligation, an ongoing obligation,
to turn over
to ensure that they do not ever present a case in front of a jury that they do not believe can be proved beyond any and all reasonable doubt to a jury of 12 objective community members. All right, that's the postulate, right? That's the baseline. They have an ongoing obligation to establish. That's the ethics of a prosecutor. You cannot just prosecute a case because it sits on your desk. You have to be convinced as a prosecutor, as an ethical prosecutor, that you can prove the case, prove all the elements of all the charges beyond any and all reasonable doubt
since the beginning of
to
this
a jury,
case.
an independent jury.
Mm-hmm.
So after the first trial, it was our thought, there's no way that these folks are going to come back to the drawing board and say, oh yeah, we're going to do this again. It was nearly 4 months the first time, 3 months and a few days the first time. It ended with, very famously now, it ended with acquittals that were not recorded. Right. Of course, the DA's office is going to go back, sit down at their desk, take a deep breath and realize, hey, you know what, guys and gals, we did the best we could. We put this case forward the first time, didn't work out. It's not going to work out any better. We don't have any new and different evidence. It's going to be the exact same thing the second time. It's going to cost the taxpayer millions and millions of dollars. We're going to take the loss and walk away. It's the just thing to do. That's the conversation they never had.
No!
But Michael Morrissey
the second a mistrial was declared, Michael Morrissey's like, we're doing it again. It was like, you need to, what? No, you need to stop, collaborate, and listen. Legitimately. And also, to quote the song, but the DA's office should have taken a few weeks to have some very in-depth discussions. And instead, the elected prosecutor was like, we ride. There's no way he even had a conversation with Attorney Lally of any substance because it was an immediate press release. Wild. It was wild to me.
He did. If he goes back to the drawing board and says, who can I hire outside the office who's willing to take this piece of garbage lawsuit and prosecute it?
Who's willing to just take the taxpayers' money?
I'll just go pay someone. I'll literally, it's offensive. It's offensive. I'm just going to go write someone a big enough check.
That's offensive.
Basically bribe someone to come on board with a big check and prosecute the case that nobody else in the office can or...
It's not bribery. It's enticement. And Brennan was apparently like, I like money. Let's roll.
Or will do. So what happened between the first and second trial is offensive. It never should have happened. And it was a complete abrogation of their obligations. And it's in keeping with Michael Morrissey's entire tenure as the DA. It's a fiefdom. He runs that like a lord and his manor. He doesn't run it like a public official. He's a disgrace. He's an absolute disgrace.
Well, those are strong words.
How deep do you think if you consider this to be corruption, how deep do you think it goes here in Massachusetts?
To its core. To its core. And that when I say that, I don't mean that every single Massachusetts State Police officer is corrupt. Not by a long shot. Most of them
not too
are
cute by half.
hardworking men and women who get up every day and do the job that would strike fear in the rest of us, right? They run toward the danger. They run toward the bullets and the fire and the fights and those things. I have the deepest admiration for the lion's share of the men and women who do that job. I also have a deep admiration for the lion's share of the prosecutors who populate courtrooms around Massachusetts. But what I've seen during my time in Massachusetts, it hasn't been all that long, a few years, going on 4 years now of working in Massachusetts pretty regularly. It's not a couple of cops. It's not just a couple of cops. What are the odds that you would get
like everybody got reassigned from Norfolk DA's office. Everybody. But Jackson is just like, let's go.
Proctor and a Buchanan and a Tully and these folks that have all been disciplined. Kevin Albert, who have been disciplined, some of them have been fired. Almost all of them have been removed from their positions in one case. What are the odds? The odds are almost zero unless the corruption goes extremely
that they all end up in the same
unless
place.
that kind of conduct is rife throughout the community of the Massachusetts State Police. And also, it doesn't just go deep, it goes high. Michael Morrissey is at the top of that list. He knows better. He damn well knows better. He's a political hack who knows better. And all he cares about is his next election. That's all he gives a crap about. Which is
Jackson's like, you can't do shit to me. I'm going to say what I think. And Morrissey does have an election coming up. So Jackson's just like, I don't give a fuck.
Offensive.
Were you surprised to see Commissioner Cox say that he had no idea that Kelly Deaver was even involved?
This is such a great question. This is such a great question. I don't even know. We're not even involved with the Karen Reed case. That interview was fucking wild too.
In the Karen Reed case.
How he would be on that, Greg. He actually said, "I've never said the name Karen Reed. That name has never crossed my lips. I've never talked about her.
Wild.
Or talked about this case. Are you kidding? Are you kidding me? One of your officers was fallen. One of your cops was found dead on a lawn of one of your cops. And one of your...
It sounds like we all had the same reaction to that interview then. It seems like we all kind of saw that the same way when we're like, a Boston PD officer is dead on the lawn of a Boston PD officer and you've never talked about this case? Seems like Jackson had the exact same reaction we did.
The third leg of that stool is one of your cops is central to the case, dealing with not just one of your officers who's dead, but on the central piece of that puzzle is it happened on one of your officers' lawns. And you're telling me you've never said the name, you don't know the name Karen Reed, you've never heard of this case, you don't know anything about it? Well, either you're incompetent or you're lying, one of the two. And now that you're saying that conversation with Kelly Dever, however she wants to pronounce it.
Commissioner Cox said, the Reed case, we have nothing to do with the Reed case. We have nothing to do with the Reed case. We'll link that below. The link of videos that are interconnected with this, it's a fucking spider web at this point. But the link of interconnected spider web cases on this is a lot. So I'm not surprised this is all intermeshed.
That never took place? Are you kidding me? Then that tells you one of two things is true. Either you're lying, Commissioner Cox, or you've just proved my point that she's a liar. Which one is it?
Well, Alan, you did have a good officer on the stand, though, for you guys, and Officer Barros. And in my opinion, watching that unfold, I think he's the reason, one of the main reasons that the jury swayed in your direction. I mean, he seemed like he was almost a smoking gun.
Nick Barros is a hero, no question. Like I said, most of the men and women carrying a badge and carrying a gun do God's work every single day, and he's among those. He is an absolute hero. He was willing to step up. There was no thin blue line. That's not the cloth from which he's cut.
He was like, no, you say it what it is.
He's going to tell the truth because that's what he does.
I saw what I
saw.
What he saw.
It's what he heard. Yeah. Whatever that is,
what I saw.
That's what he's going to testify about. And that's what he did. He had the guts to get up on the witness stand and tell the jurors exactly what he saw. And what he saw was, and what he established was, that taillight was not broken, not completely smashed out when Michael Proctor first got a hold of that truck. It did not look like it did after he got a hold of it, and after all those taillight pieces were found at 34 Fairview. That tells the jury all they need to know about the condition of the taillight and what Michael Proctor and his people were doing with that car.
Alan, who is in the running to play you in the movie?
I thought it was you. You and I talked about this, Greg. You said it was you.
You know, I have done some acting.
You're going to have to go to Modern Pastry and just eat there for the whole civil trial for that to work.
He has an IMDb page, not a big deal.
I mean,
just coming for Greg.
I think there's an undeniable
very
likeness.
radio.
Come on.
You don't know?
Yeah, I have no idea. Who knows? Who knows? Right. Danny DeVito, maybe? Yeah.
Well, I appreciate you taking the time, and
Chat wants John Stamos.
I think that you are.
Chat immediately wants John Stamos. Chat immediately wants John Stamos. Chat has voted for John Stamos. Crystal, I mean, look, he knows the case. I'm not mad about it. He likes the case. It makes sense. Some of you are saying Robert Downey Jr. You can't do Ben Affleck. Ben Affleck has too much of a Boston accent. Maybe if Ben Affleck shaved his head, he could be Yannetti. What do you think about that? How about Affleck for Yannetti? Maybe.
Are now joining that team that will not only defend the civil case with Karen, but also and decide whether or not there is a lawsuit to be filed. So, Wiggy, did you have one?
No, the only
Alan
question
goes?
I had for
Alan, Wiggy didn't watch much of the trial. I couldn't get him into it. I tried.
He wants Idris to play.
Who doesn't get fascinated by this trial? I don't understand. This trial was fascinating. But maybe not. Maybe not.
Yeah.
Yeah, exactly. Wiggy, I'll take my apologies now, Wiggy.
No. Believe me.
My apology now.
Listen, the one thing I learned growing up as a kid: always know a defense lawyer. The thing I would just ask is, in this situation, you talked about the money the state spent. Clearly, Karen spent a ton of money. Where does she go?
Spend as much money.
I mean, it's probably impossible for her to get her life back, but where does she go to be able to recoup some of that money to pay you guys off?
Yeah.
That's it.
Movie deal, book deal, traders? Question mark? You guys let me know what you think. Movie deal, book deal is a start.
I mean, look. First of all, I don't care about the money. I've made it pretty clear in other forums that's not why I'm doing what I'm doing. I'm doing it because it's the right thing to do. Every once in a while, you have this magnum opus case in front of you as a lawyer, and you better be willing to step up and do the right thing. Look yourself in the mirror and realize at the end of your career, there have been times when people have needed you, people in need that can't do what they want to do and need to do. Without you, and you're just going to step up. So that's what we did.
You say that, Alan, you say that and people lose their minds. They say, there's no way this guy's working for free. Think of the
Look, here's how I see it. First of all, I'm just giving you my thoughts before I let Alan finish. First, we heard what Alessi had to say about his firm's pro bono and his firm stepping in and saying, yeah, sometimes you just have to do the right thing. How does that benefit their firm? You can't buy that kind of advertising, first of all. And it only works if the attorneys are good. So Alessi's firm trusted, and of course they did, they know him, but trusted Alessi to go in, not only represent himself well, represent the firm well, and believed in the case and believed that they were doing the right thing, regardless of the result. Same thing for Jackson's firm. Karen Reed's attorneys have said, hey, we are not getting paid attorney fees for the second trial. We are going to pay for our experts. That's it. But Jackson is also part of the rights for the movie, part of the rights for the book deal. Will he make some money off of that? Maybe. Will he have some control over that, which probably is the bigger interest, is for him to make sure that he is involved in it, to make sure it is represented properly. But I imagine the work that his firm will get from this case is substantial and cannot be underestimated. But also, for lawyers to be engaged in their profession and to get to go to trial and fight for justice is something that you don't always see. You don't see cases like this. And in private practice, a lot of cases will resolve even if it's not what you want to do. You guys remember how heartbroken Attorney Steele was when the YSL plea went down. Attorney Steele looked emotionally kind of gutted that his client was done. He was not ready to be done with the fight on trial, but your client gets to choose. And so for Jackson to look at this case and say, this case doesn't make any fucking sense, and to then have a client who said, I am not going to stop at all. We are going to trial and we will see where it goes is a unique thing. And then to have the facts that they had is a unique thing. So it makes perfect sense to me for someone who wants to do trial work and did the work of a DA and is just offended by this whole fucking thing. I get it. Jackson's whole vibe on this is, are you not embarrassed? And what the fuck are you doing? And that's before he even knew about the crash daddies. So that doesn't surprise me at all. And I know people are surprised, but the thing about being a lawyer is if you do your job well, that'll come back around. And his firm was also cool with it.
All the attention that he's gotten out of this. Like, what's your answer to that when people say that?
My answer is that's exactly what's happened. I have not asked for a dime from her because it's cost her life, not just a bank account. It's not, she was not a rich woman to begin with. She was doing just fine. She was doing just fine, and she was, certainly better than a lot of folks financially. She was not a wealthy woman. It cost her everything. It cost her life, her reputation, her
she's not
job,
a celebrity
her
client.
professorship, her entire bank account. She had to sell her house. She doesn't have a car. It's cost her everything. So what am I going to do? Sit there and peel off more layers of that onion? If she were to get some sort of reprieve, some sort of financial reprieve, I couldn't live with myself. I could not live with myself. So every once in a while, it's just the right thing to do. So I don't know where she goes to sort of get her life back. She's going to try. She's going to work for it. She's not going to try. She's going to succeed. She will get her life back. She's going to land on her feet. She already has. This is the first step in that process. But I'm not worried about Karen Read. Karen Read is as tough as nails. She's as tough as shoe leather, and she's not going to let this get her down. There will be another very, very significant chapter to her life. What that looks like, only time will tell.
I'm gonna lock your number in.
Yeah. You may get a call. You may get a call from Wiggy Al.
Yeah,
I might know somebody. I might need you one day.
I like your pro bono.
That's what I'm talking about.
Civil
That's a number you hold on to for sure.
trial not live streamed, correct?
Doubtful. No,
Okay.
there hasn't been a request, a media request that I'm aware of,
But there will
and who knows
be.
what the judge would do in that case. But it's very, very unlikely. Very unlikely.
There will be media requests.
Alan, you're
in that
welcome on the
case.
show anytime, and look forward to catching up when you get back here in Boston, which became your
You
second.
guys are great. Yeah, keep a bowl of chowder warm for me. I'm coming back.
All right, Alan
The
Jackson,
chata.
thank you for taking the time, and we will be right back.
All right. And with that, we heard Alan Jackson share this morning on the Greg Hill Show. Local. Look, I love local radio. I love my Carson and Kennedy. But you heard Alan Jackson sharing that he is joining Karen Read's civil team, that he does not want to take any financial compensation from what Karen Read has done in the past or is going to be doing in the future. They talked about his very strong thoughts about Michael Morrissey. And look, Alan Jackson is someone who ran for district attorney in Los Angeles. He is someone who worked at all levels of the LA district attorney's office and was a supervisor in some of the most prestigious units in the office. So the man has some opinions about being a prosecutor and what that job looks like, and was not afraid to share them. So as the Karen Read civil prosecution, that is not right. As the Karen Read civil case moves forward, Alan Jackson very much indicated that what we can expect in the civil case is a full airing of things that didn't come in the criminal case. And that, I imagine, is going to be why, unlike a lot of civil cases, this civil wrongful death case likely won't settle. I will link where I've covered the beginning of the civil case. We will cover the civil case more. The civil case is going to take time. So it is not the most urgent top of the list, for sure. Not the most urgent top of the list, but we will get to the civil case more. What I want to clarify is, because even though judges ride circuit in Massachusetts and switch what courthouses they are in, and Judge Cannone has rotated into civil, at the moment, be clear, this is the docket for the civil case. At the moment, this is assigned to Judge Daniel O'Shea. So this is not assigned to Judge Cannone. This case is assigned to Judge O'Shea. So that's where that is. I've seen a lot of confusion and questions about whether this will be assigned to Judge Cannone. It is not assigned to Judge Cannone at this point. It has a judge. It should likely stay with that judge. Could something change down the road? It could. But it's not likely that we will see that crossover. And I wonder if Alan Jackson taking the case almost ensures that, because I imagine If someone came to Judge Cannoni and was like, hey, we're rotating you to this case, it's like, assign it to somebody else. I'm out. But Judge O'Shea is the judge that is assigned to that case. So no, Judge Cannoni is not assigned to that case at this time. And now that Alan Jackson is part of that growing defense team on the civil side, maybe we'll see it stay that way. So what have we learned today? Well, there's a lot more afoot in the fallout from the Karen Read case than I thought we would see. We knew there was going to be fallout from the Karen Read case. We talked about the fallout from the Karen Read case, but the ripples aren't done, and there is going to be more, and we will keep covering it. I cannot tell you I'm going to cover every trial that is a case that's a Proctor case, but I'm going to keep a look and keep an eye on the discovery issues, because there is a lot that's going to happen in court trying to parse out what discovery looks like in other cases. And that is something I'm very interested in. And then we will decide case by case what we cover, what we don't. So we are going to be looking at other cases. We're going to go to a different court tomorrow and cover a hearing. So do not worry, we will still be covering other cases, but I am still going to be looking at these cases because there is more to come, and there's more we're going to learn. And in the civil case, there is going to be a tremendous amount of information it seems that the defense wants to bring forward. I've seen the question quite a lot. Will we see the depositions in the civil case? Unlikely. It's really unlikely. The only reason you would see depositions if they come up in trial, and if this civil case goes to trial, which we'll see if this civil case gets to trial, because the plaintiffs can always choose to drop it if they want to. If the civil case goes to trial, maybe we will see some of it, but I would not expect to see it. Court filings, I will keep up with, and we will go from there. But no, I wouldn't expect to see depositions just publicly released. Those only come up in the context of a trial. And we're not there yet, but there are a lot of other cases I have an eye on. We cannot just park at Logan. As much as I love Massachusetts, we can't just park in Massachusetts and stay there. There are lots of other cases. And, I'm very ADHD, chat. This is shocking to all of you. It's shocking to no one. The cases that are closer to trial are just, as this one got covered more closer to trial, the cases that are closer to trial will get covered a bit more. And then we will keep checking in on this as these cases go. The things that have court hearings, like the discovery hearings in the King case, we're going to be looking at, because there's still the possibility that Proctor and Lally are going to be on the stand. And now I'm invested to see what they have to say. Like, how did discovery take so long? I would also like some answers, and I would like to see what the court's going to do. We're going to get to some questions. And then we're going to have to go because it's been 4 hours. And then tomorrow we're going to check in on the Corey Richins hearing that happened yesterday. And we'll talk a little bit about more of what's going on in the Corey Richins case. And then next week, we're going to have to jump back into talking about Florida, because there is a lot going on with Donna Adelson. But we will get into that next week. Because why? Because Emily is going to Indy. That's why. Emily is going to Indy. Emily is going to go see Travis and the Cavaliers perform at finals. I have quite a lot of thoughts. And before we get into questions, Kathy, you are not the only one. Kathy Woodley and others said, are the DCI competitions live streamed anywhere? Why, yes, they are. I have told you guys that we had been working on a link with FloMarching. And trust me, I have a list of things I would like to work on for next season, but we're at the end of this season. Excuse me. So we do have a link to share with you with FloMarching with a discount. The discount is off of a year of FloMarching. For those of you that are like, I literally just want to see DCI finals. If you want to sign up for a month, you can sign up for a month. Finals will be covered. But we have a link that the mods are going to share, and we'll link down below for, thank you to Octo. Warren made this lovely page answering all of your questions about FloMarching if you have questions. But we have the only discount that exists, which was part of our chatting, because they have an affiliate program. And I was like, can we get a discount? And they're like, it's going to take some time, but we'll work on it. We have 15% off the annual plan at FloMarching, which you can, if you want to watch other things that are part of the Flo universe, you can watch WGI when it gets to Winter Guard. You can access those other things, and you can watch the rebroadcasts. The rebroadcasts air just like a program, and you can go into Flo and see the list of what's being rebroadcast. And the rebroadcasts are re-airings of previously aired DCI events. The replays that are more like a YouTube VOD often do not have sound on Flo because of copyright. But if you look at the rebroadcast schedule, you can go and catch up on things that you might not have seen. So if you want a year, you get 15% off the year. If you want the month, you can get the month. You can click the link and go through all of the year with Winter Guard and Bands of America and DCI and the rest of it. So you can use Flo on your phone, on their app, on your smart TV, on their app, on your computer if you want. And for those of you that, here, I'll show you what my account looks like real quick. Let me just log into FloMarching, and I will show you what their rebroadcast schedule looks like. Because there's going to be, why is my keyboard not working? That's super helpful. All right, well, I'm just going to put this up so you guys can see our lovely page for your exclusive 15% off. I didn't tell you the link. I'm sorry. The link is pinned, but the link is a nod to the Law Nerds. So if you want to head to emilydband.com, it will take you to this landing page. So if you go to emilydband.com, it will take you to the landing page. Things to also know about FloMarching. FloMarching often has two options where you can watch the high cam or the multicam. The multicam edits between close-ups and closer-ups and the full field. The high cam is just the full field. So you have that choice on any given stream. And let me see if I can get this back logged in so I can show you the upcoming schedule. So let me make sure. Am I logged in? I am logged in. So I'm going to my FloMarching account real quick. I use this through the app the majority of the time, and through the app on my smart TV. You can also cast it to your smart TV if you want to, but you can access it on the web easily as well if you just want to go through their website. So it's up to you. Let me switch over and show you the rebroadcast. So you have open class for DCI finals today. FloMarching Radio is live. The rebroadcast starts today at 4 for the DCI open class, and then the rebroadcast at 5:30. So if you go into FloMarching and look at the schedule, you can find those rebroadcasts and watch those when they air. I know, like old school TV style, you go in and watch them when they air, and then the rebroadcast are the full event. And then on the 7th, you've got the DCI World Championships. On the 8th, you've got both. On the 9th, you've got both. And then Sound Sport will be re-aired on the 10th. So those rebroadcasts, you can go and watch what has been rebroadcast. And those, you just click on them and they will start at the time that they are ready to start. And they do have limited replays. Not all of those have sound. It really just depends on what you are watching. The rebroadcast is where it's at. And then they have a whole watcher's guide so you can find what you want to watch. And then you can explore WGI and the rest of it. So if you do a 1 year, it is 15% off. If you want to sign up for 1 month, that is an option as well. So it's up to you. Emily D Band, and head on over to emilydband.com and then you can go through it. And if it breaks, I'm sorry. Rex88 says it's not international. I do not know what the international broadcast availability is because copyrights across borders can get really complex when you were looking at composing copyrights and broadcast copyrights vis-a-vis live performance copyrights. So that can be difficult, but I get it. Copyrights is one of those things. Emily said in the chat, Cavaliers are staying at my high school. I'm going to watch them practice tomorrow. Have the best time. They tend to do some great run-throughs in the evening. Just enjoy it, because they will be practicing till late in the evening. So have fun. And with that, we should just get to questions, which kind of feels like, I don't know.
Mention it all. Mention it all.
We just need to get there. Norma asked the same question so many of you asked, do depots ever get released? No, not unless it's in context of like a trial. But in court, but to the public, no. They should, often they have protective orders, but they should not just get released in that way, if that makes sense. Let's see. Creekside Casual said, if Karen Reed wins the civil trial, can she get all of her legal fees paid, including for the criminal trials? The criminal trials are completely separate, so no. That would have to be a separate process. And if she's found not liable on civil, it doesn't automatically entitle her to attorney's fees. So there are too many, but if this, then that's. So not necessarily, but not for the criminal case. That's part of why Jackson's being asked, hey, I forgot to put my earring backs on, another fighting with me, but it's part of why Jackson was asked, is she going to pursue her own civil lawsuit? Because in the wrongful death suit, she is a defendant in that suit as well. Alessi's fantabulous lexicon said in the chat, Jackson's very candid, very humorous, no F's given, responses are giving me life. Oh yeah, he's just like, I'll tell you exactly what I think. He is curated being unfiltered, well, cautious, well, because it is a bit unfiltered, but it is not unintentional. So not unintentional as well. Casey Cat said, since Canoni is in the civil court now, could she get the O'Keefe civil case? It's not assigned to her. So I suspect that we will not see that. I would be very surprised if we did. So I suspect that we will not see that. So let's see. Madeline asked earlier, can you explain how it's prejudicial? When we're talking about the Myles King case, I need to go through their motion to dismiss. What's hard is the defense hasn't identified which things. So I need more information before I can really make that argument, because it depends on the thing. But the crux of it is irremediable. I added a syllable, that it can't be remedied. So the irremediable nature is the issue for the motion. Most courts are going to find, well, you have more time. Having more time is the remedy. So it has to be something that cannot be fixed with more time. And that's what was being argued in Karen Reed's case with the video that was gone. Your Honor, it doesn't matter how much time you give us, the video is still gone. So it's gone. That ship has sailed. Rex asked, Emily, please have a DCI members only after championships. We will do more of a DCI members only. And then for those of you that are members, excuse me, the tech test is still up. We talked quite a lot about DCI during the tech test as we were doing that. And we will probably do another tech test soon. Thank you so much for the gifted memberships. I appreciate it so much. Thank you. For those of you asking about Adelson, don't worry. We will be getting back to Adelson for sure. Let's see. Miss Simone said, Emily, I'm in my 30s and in the process of being assessed for ADHD, but I will refer to it as neurospicy. You can refer to it however you like. It is your choice. But yes, sometimes it's helpful to give neurodivergence its own little category. It's like neurospicy brain. I find a lot of people in the neurospicy world, no matter how you are neurospicy, tend to blame themselves for things that are not personal failings or things that they have done. It's just attributes of how their brain work. And I find that my neurospicy brain, as being neurospicy, helps limit the added stress of blaming yourself for something that you did not do, cause, and that is not your fault. So that. So Trish 818, the bar in, sorry, I didn't even repeat the question. Trish 818 in the chat asked, what could be an example of what could cause a case to get dismissed? The standard is different in like the Baldwin case. than it is in Massachusetts. It was also different timing. I would need to go for Massachusetts, pull some appellate cases and see where they've upheld it, because it seems that in the appellate cases, a lot of the case law in Massachusetts leans towards do what you need to do to get a trial or a new trial or delay the trial. And almost everything is pushing towards, well, if you have time for a trial, then it'll be fine. Brandy Rose, good to see you, said, celebrating my 8th anniversary tonight. Congratulations. But first, the hair looks great, Brandy. I love the new color. It's so good. But first, EDB Law Nerds and pumpkin coffee cake iced coffee. Okay, that sounds amazing. It is almost pumpkin spice season. The weather doesn't feel pumpkin spicy. I'm ready to be pumpkin spicy. I'm ready. I'm ready to be pumpkin spicy. I'm ready. The other Aaron mentioned this much earlier in the chat, and I had to save it. Remember the pole vaulter in the Olympics who hit the bar? I feel like it's the beginning plot line to a book. But yes, I do remember that. Yes, I do. How do we forget? The internet wouldn't let it go. It was kind of funny. Liddy said, my son-in-law was diagnosed when my grandsons were evaluated. That happens quite a lot. It happens quite a lot. It's sometimes, I think, why it's harder for kids to get evaluated if their parents don't know about their own neurodiversity. Oftentimes it is teachers doing the Lord's work saying, hey, we might just want to explore this a little bit. Often the parents don't clock anything because they're like, I'm like that. Like, that's not how everybody is? Wait, what? Wait, what? Really? Other people function differently than this? I had no idea. Especially parents that have masked well for their entire lives don't always clock it. And it can be one of those things where it's like, wait. So what you're telling me is that like all of this is like a thing. I don't need to just like apply myself or try harder. Right. So that's why it is oftentimes that going through it with kids, you can look at that and go, oh, wait a second. And sometimes the diagnosticians will also be like, which parent is the neurospot, or is it everybody? It just depends on who is helping navigate that. I often think, look, when you have physical things going on with your body, doctors are very happy to tell you whether it is a twisted ankle or a broken arm or high blood pressure or whatever it is. We very much will label the thing and then figure out how to either fix the thing or try to prevent the thing or whatever it is. And we do not do that as much with processing. So we don't always talk about how people process what executive functioning is. It's getting a lot better. But if you don't know that that is just a struggle more particular to you, it's like you just blame yourself. Oh, everybody else is getting their things done faster than me. I must be slow. No, your brain process is different. Oh, everybody seems to have an easy time with this. I must be doing something wrong. I need another system. If I just had a better process, it would be better. It would be easier. I need new hangers. It's obviously the hangers are the work of the devil. And that is why the clothes do not get back into the closet after they are dried. If I had new hangers, it would be better. But you know what? If I have new hangers, I don't really want to get new hangers because I really need like new shelving in the closet. And actually this hanger rail is like too low because somebody decided it needed to go there, but that's not right. So that needs to come out. So, okay, I will get new hangers, but first I need to redo the closet. And if we already need a new bar and that one's too low and we need more drawers, we probably need to paint it. But if we're going to paint it, I also hate the light in here because it's evil big light and ew. So if we're going to redo the light, then we need to do that, except like, then we could add new outlets in here. And then if we add new outlets, then we could get dimmers. Where do you even get dimmers? I don't know where we get dimmers, but if we get new outlets with dimmers. Can we also get the ones with the pluggers on the side? Because that would be amazing. So I need some of the ones with the pluggers on the side because that would be great because then I could charge. But if I'm going to charge things because now I have a new light switch that has the dimmers with the little pluggers on the side, but then if you have the pluggers on the side, you need to put something there. So we probably need a shelf there. So now we need to redesign the entire thing, but we should paint it too. And I need a new light for above. So let's pick a paint color, but then we need to sketch out what we're doing. But I can't really appreciate the space in the closet to decide what I need until I take everything out. So I need to take everything out of the closet so I can really evaluate what I want to do with the closet. And so if I get everything out of the closet, then I'll be able to figure out what hangers I need. And then everything is on the floor for 7 months. Because then you're like, what was I doing? What was I doing? What was I doing? I needed to get my clothes put away and I needed a better process. So I decided that I needed new hangers because new hangers were the dopamine I needed to put the clothes away. But then the clothes were hanging in the wrong spot. And then the big light pissed me off. And now we're in a full closet remodel. For everyone who feels seen, I know. Been there, done there, in the middle of it with digital. I get it. But if you just had like a broken arm, a doctor would tell you, hey, you have a broken arm. You need a cast. You need to rest. These are the things you need to not do. But when you have executive functioning quirks, nobody really looks at you and says, hey, so your brain's a little quirky. And if you don't rest, you're going to be super fucked. But your brain's a little quirky and you have to figure out how to roll with it without letting it derail everything. Sometimes you have to just go with it. Sometimes you can't go with it. And sometimes you have to trick yourself into novelty. And then you have to figure out how to make all of that work. And then when you look at your coworkers or friends or family members or whatever and go, why is it so easy for them? They don't seem tired. Your brain is working differently. You are working differently and you are using more energy. And when they do scans of people with ADHD, these are the ones I am most familiar with, your brain processes differently, like neurologically, and uses energy differently and lights up differently. Our brains work different. But it doesn't help if nobody chats with you about what that means for you. And it doesn't help if you don't get to have those conversations with other people who get it. And also people make you think you're rude when you're just like, I'm sorry, what were you saying? And in your brain, you're going, you were talking so slow that I lost track of the conversation. I apologize. My brain filled in things that were more interesting. My bad. It's not just that you're not paying attention or that you can't focus. Your brain immediately went boring and just moved on. We process information very quickly. The problem is we are processing information more quickly than others, but then we can't follow through with the things because our brains have already moved on and the world is set up for boring. There is a scene in Center Stage where one of the dancers keeps doing a triple and the instructor is like, it's a double. And she just keeps doing a triple because she is spinning faster. And she's like, wouldn't it just be better if everyone did a triple? And I feel like for all of my neurospicy folks, a lot of us just live in a world where everybody's doing a double. And we're like, a triple's more fun. Couldn't we all just do a triple? And everybody else is like, we don't have enough space to do a triple. And we're like, I'm over here tripling all day long. You're fucking me up by making me do a double. Like if I have to slow down for you, I'm screwed. So for all of you out there that are like, there's just enough room for a triple, it's not your fault. And it's really hard to navigate back to sometimes you have to do a double. Or you have to build a world around you where you can just do a fucking triple. We need to find that scene. What are the chances I can find that scene? This is why our 4-hour stream is now 4.5 hours long. Hold on. The non-ADHD, non-neurospicy folks have already bounced right out of the chat. So don't worry about it. The canned heat dance is so good. I really like Center Stage. Let's see. Let's see if I can find, let's see if somebody has clipped this exact, hold on. I don't know if this is it. Let's see if somebody has clipped this part. I think this actually might be it. It is the wildest recording, but yep, found it. Okay, to whoever just grabbed a phone and recorded this off of their TV, I applaud you. For the MPAA, hey, welcome to education and critical commentary of how ADHD is represented in film through dance. Thank you for coming to my TED Talk about how ADHD is represented in film through dance. So for educational purposes, let's just bring everybody up to speed on the reference to Bring It On.
Anna, I asked for a double pirouette there, not a triple. Again, please. Anna.
Ma'am, Anna is just ahead of her time.
I want a clean double.
I'm sorry, I thought there was enough music for 3. I mean, wouldn't it be better if we all did a triple?
Yes. Yes, Anna, it would be better if we all did a triple. It would be better if we all did a triple. Yes, it would. Everyone else is just spinning too slowly. It's not Anna's fault.
A double.
No, not a double. A triple. Stop battling of the wills. So, no, a triple. Let Anna spin. ADHD represented in film through dance. There was definitely enough music for a triple. Anna's correct. Anyway, so thank you everybody for however we ended up on the soapbox of ADHD. The movie is Center Stage. It is when did Center Stage come out? Chat, let me know. It is a dance movie. It addresses the dark side of dance too. So just a note on that. Let's see. I really like the film. I enjoy the way it represents everything. Just Rhonda says, so this is why streams last 3 to 4 hours. Yes. Yes, the red point shoes are so good. The end is so good. This was only supposed to be a hour. No, we were supposed to do like a 2.5 hour stream. We were. So for everyone, and I saw a number of you say it was you talking about ADHD that made me go, huh, that was me. Maybe I should ask some questions. Yes. Mary Kate said, I thought I was misdiagnosed because I was like, I pay attention in school. I don't move around all day. They need to focus on the executive dysfunction aspect. Yes. And depending on who it is that is neurospicy, some of us, the racing thoughts is the hyperactivity. Some it is physical hyperactivity. And a lot of people, when they say attention deficit, are like, I hyperfocus like a motherfucker. You can't always rein it in though if you're hyperfocused on something. Like, you are hyperfocused on a thing and you know you have to stop doing the thing to like do another thing, go to an appointment, eat, sleep. And you're like, but I can't. Like, I can't stop the thing I'm doing because I just have to finish this thing. And my brain will not let me stop until this thing is finished. And I don't care if that thing is schoolwork, research, building a new civilization, finishing GTA 6. Just kidding. Whatever the thing is, that hyperfocus, a lot of people go, but I can focus when I'm interested. Right. It's the difficulty in shifting that focus to the shit you're not interested in that is difficult. Others apparently can go, I really want to do this thing. I need to go do this. I'll come back and then do this. And then they just do it. I don't know what that's like. Like, oh, I enjoy this thing, but I got to go do that. I'll just go do that and come back. And you can't choose when to hyperfocus. And sometimes you're like, oh, and now it's 5 a.m. Awesome. So it is tough. And they have now identified all different types of ADHD. But for those of us that grew up OG with like, it was like, oh, if you're not physically running around a classroom, nobody thought that it was ADHD. I get it. We find it later in life. So it's a whole thing. Let's see. Tinks82 said, who thinks Emily would be a fantastic judge? Emily does not think Emily would be a fantastic judge. CEG my entire rant about ADHD. Your Honor, cases are ready to be called. I'm not done color coding my calendar yet. Wait. Or, excuse me, counsel, can you speak faster? Because you're losing me. Or, what? Yeah, no. Also, it's a lot of tedious paperwork. Like, it's a lot of tedious paperwork. And that part I would not like. Curious Nonsense said, EDB, but how can the defense know what they don't know without an evidentiary hearing questioning Lally and Parker? Curious Nonsense, this is a fair question. The evidentiary hearing is more about the egregious conduct than it is about what the evidence is. And that's what the court is trying to flush out. I completely understand. A lot of y'all are like, I am so frustrated. And Belle, this is a fair point. Some of the Pelican cases I've looked at are heavy. Some of them are not. I need to check again. Let's see. Z said pre-hearing defense received 200 items and more post-hearing. I know. I was baffled when there was new shit during and after the Karen Reed case. It was so crazy. It was wild. Your mom's new accountant said, love hanging with the law nerds, relaxing after having an embryo transfer, trying for frozen baby number 2. Congratulations and best of luck to you and baby. We are putting all of the positive vibes. Let's see. Norfolk DA's office, multiple facepalm moments. I can't imagine other members of the office are like, why can we not get it together? Why? Phoenix Paul said, a friend of mine has a cat named Mr. Butters with cream-colored fur. And do you just go, would Mr. Butters like his dinner? I mean, how do you not just go, Mr. Butters, this is what we are doing now. I love it. I love it so much. I'm going to try to get to like 2 other questions. And then we're going to roll. Lots and lots and lots of you asked about the depositions. Not unless it comes up in trial. Sorry about that. Celestial Faye Starling, I will take a look. I will take a look. I've got your comment. I'll make a note and take a look into it because I do not know, but I will take a look. Tomorrow we're going to be in Utah. Then I am going to be at DCI Finals. Follow along with me at Emily D Band, and on social I'll be sharing there. And then we are going to be looking at Donna Adelson as that case gets ready for trial, and then catching up with some of the other cases that we have not caught up with yet. I will probably not bring in any new cases unless it is food court and or kiss cam nonsense, which I don't think a lawsuit will ever be filed, but we'll see, before we get into the Adelson trial that's starting later this month. So because Adelson is going to trial in August, at least as of now, that is my plan. But if Adelson gets bumped, which who knows at this point, if Adelson gets bumped, then we will pivot. But if it doesn't, then we will be in trial. So we'll be catching up on the Adelson case a little bit with some more trial coming up this month. But you guys were here with me when I'm traveling to go drop T off for the summer. You were here with me when I'm taking T to his pre-spring training camp. And we did a lot of that during the Karen Reed case. And now you blink and he's going to be coming back home. And I'm very excited. I can't wait to see him. If you see me walking around in Indianapolis, well, I'll be inside of Lucas Oil. Just yell Emily and I will stop and say hi unless I am racing to my seat because the Cavaliers are about to perform. If we are not within 10 minutes of a Cavalier performance, and probably Boom too, to be perfectly honest, then I'm always happy to stop. And even then I will stop and say, I've got to scoot to get to my seat to see the Cavaliers perform. But I look forward to seeing those of you that are going to be there too. I will keep you in the loop on social. I imagine I will be posting in the evenings, but we will see. So Law Nerds, thank you for being here. Thank you for being a Law Nerd. If you want to watch along, you can sign up for a month of FloMarching, or if you want 15% off, you can get 15% off at FloMarching. That is an affiliate link. I'm an affiliate through them. So if you do sign up, that means I will also be compensated a bit. I just want you to hit the link because I am so excited to try to create some Law Nerd specific marching packages for next year. And the more of you that hit the link and show your interest, the more I can say, look, the power of the Law Nerds. And I'm already excited for next season. Emily, you're already looking ahead to 2026. I am. So if you want to watch along, even if you have never jumped into the marching arts, well, watch along. Great music, incredible artistry, and a really, really tight race right now between 1 and 2. And while I don't give my opinion very often, and I might make some of y'all mad, it's Boston's year. I am sorry, Bluecoats. I think it's Boston's year. I really do. I am rooting for the Boston Crusaders. I can't wait to see how Cavaliers do at finals, but how close they are between the Bluecoats and Boston, it is just so close. Boston has never won. Bluecoats are reigning champions. Like, ooh, it is going to be tight at finals, and I'm really interested to see what happens. I think Boston needs a win. That's where I'm at. Boston, we're rooting for you. We're rooting for you. Go give lots of love. Bostonians, go give the Boston Crusaders all of the love on their social medias. Just give them the push. They have never won a championship. This is their year. This is their year. You can feel it. I can feel it coming in the air. Go show the love on their Instagram pages. It's going to be fun to watch, but it is, it's going to be close. It's going to be close at the end. And we will see. So there's actually a really interesting competition working out, and it's not a foregone conclusion. So if you want to root along for the rest of the season, I'll see you there. All right. I'll see you guys tomorrow. We're going to be in court. I'm not going to say it's going to be a shorter stream because I make no promises anymore. It'll be what it'll be, and I will see you in court tomorrow. Bye. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android, so I can keep you in the loop, because you never know when something's going to pop off. Thanks for being here, and thanks for being a Law Nerd.